We have come up for this writ petition for relocation of a grill industry, fabrication industry located in a residential area. The drawing, Lordship, I would like to take Lordship to page 24, the drawing of the residential area where the fabrication industry was located, Lordship. It is just 10 meters away from our residence. It is a purely residential area. Then about 42 meters from the hospital, almost about 100 meters from the school, 10 meters, 50 meters away from the roadside on the riverside. We have made complaints to the local administrations as well as the pollution board, Lordship, but no action has been taken. There is a severe noise pollution created by this industry, which is beyond norm, Lordship. We have made an RTI. At page 93,
What about the service upon response number 8?
all it has been done, Lordship. Already last order is there, Lordship. We have taken fresh steps. It has been done. None appeared.
Has the affidavits been filed by the respondents?
Yes, pollution board has filed at page 95 onward, Lordship. 94 onward, Lordship. The pollution board has also admitted at page 96, Lordship. Para 4.
Yes.
I'm appearing for the admission lots. Actually, NOC was given by the Vatamari Gaon Panchayat lots. Page 32.
Where is the pollution board?
They have appeared on the last date, Lordship. They have appeared on the last date. They are appearing for pending counsel.
Yes, correspondent on 9 lots.
You are appearing for response number 8 or 9? Yes. How are you functioning with in a residential area? Are you functioning in a residential area?
No, Lordship. Initially, it was a residential one, but the in order dated 18 March 2023, Lordship, it was changed the location lot as a business area.
You've changed.
Yes, Lordship.
We have no information. They have not filed any affidavit, so we have not, the documents have not been provided to us.
It is no longer in front of the petitioner's house.
No, just near to house. Location has not been changed.
So now it has become commercial.
Commercial, Lordship. And the pollution control board, Lordship, has also filed an affidavit, Lordship. It
Who?
filed pollution control board on 25/8/17, Lordship. There is a inquiry, Lordship. As per the inquiry, they have submitted a report, Lordship. Kindly see the affidavit, Lordship, filed by the respondent number 3, Lordship, and the page 7, Lordship. It has clearly mentioned, Lordship, the noise level in the at the complaint residence is the beyond the limit, Lordship. Is mentioned, Lordship. Noising monitoring report, when machine was not in operation, the following results are found, and when the machine was in operation, the following results are found, Lordship. And when is operation, the complainant residence is 51.0, Lordship. The limited level is 55, Lordship.
Ask
So-
Mr. S. Burwa to appear. Mr. Roy, like out here in Assam, in Gauhati, we have various zones. Industrial zone, commercial zone, residential zone, semi-residential zone, semi-commercial. Do you have the same thing in rest part of the state of Assam?
There shall be Lordship, otherwise Lordship, how we valuation comes like that commercial place.
The use of
land.
the area. Commercial, which is being made by the circle officer, is only for collection of tax.
Yes.
This is done under the Assam Reassessment, Assessment and Reassessment Evaluation, that is Act 1936, that Act.
Lordship.
That is a different thing. This is for collection of tax. But my question is, do you have something to the effect that there is some residential zone or industrial zone in rest parts of the state?
In that regard, Lordship, only pollution control board may have, because there are sound control, they may have, Lordship. Because in residential area, that cannot be sound pollution.
Let us see the noise pollution, environment economics.
TMC also have.
No, we are not in. This is Boitamari.
Rural area also. Rural area.
Air Pollution Act, Air or Noise Pollution Act. What is the act you are referring to?
We are violation of our rights, Lordship, for the.
Mr. Poddar, violation can be when there is a right being conferred by law.
Yes, Lordship.
Where is the violation?
Peaceful living, Lordship.
Peaceful
In a
living.
residential area, they have constructed in a
Full
residence,
living is a
Lordship,
different
and
thing.
that too against the noise pollution, Lordship. Beyond the standard prescribed on the noise pollution, Lordship.
Noise pollution act. Yes. What is your violation?
Because they have to, their industry has should not create any noise pollution. And as per the affidavit of the pollution board and the RTA reply we have submitted, Lordship, minimum standard is 40 and 50 silence zone, but their industry is creating 85 near the workshop. Much beyond. the-
Workshop is inside, your residential home is inside.
Just next side, Lordship.
But
That's it.
inside your house, it is 51 decimal. And the
51
minimum
when-
is.
when the industry is not
permissible
in
limit is
operation, Lord.
55.
When the industry is not in operation,
No. When the industry is in operation, inside your house, it is 51 decimal.
at the
And
main
when-
gate,
When
Lordship,
it is in
68.
operation near your gate, it is 67. And when it is nearby, when it is inside his factory, then it is 81.
That is also beyond the all levels, Lordship.
Whether it is inside, that is not causing you any difference. When you are inside your house, it is 51, which is
Beyond-
within
beyond
the
level of-
permissible limit.
That is also beyond level, Lordship.
No, inside your house, it is within level. That is
As
what
per,
the
as per the
affidavit
page
says.
7, what given is 50, Lordship. Page 7 of the
Yes,
affidavit
read
of the
it.
pollution board,
Read
Lordship.
paragraph 4. Read paragraph 4.
Permissible limit is 55, but in the report, Lordship, what they have, silence zone 50, residential zone 55.
Here you see on 21/8, 42 meters from the workshop, it is 49.9. Permissible is 55. Then at the complainant 51. Then residential zone, it is 55. Now commercial, it has become, now it is 65.
This is a purely residential zone, Lordship.
No, respondent number 9.
If it is statutorily permissible to have it at 55 and inside your house it is, how can we ask them to close it?
Because it is also near the hospital.
And more
56,
particularly when now it has been declared to be a commercial area.
The commercial area does not mean that they will create noise. That's my submission, Lordship. Commercial area, they can activity, other business activities, Lordship. But industry, running of an
You
industry.
go to Fancy Bazaar, isn't it a ruckus out there? Huh? With the now noise pollution. People still stay there. Huh? If it is beyond it, we can ask them to close down or do something. But the problem is that the Pollution Control Council is not there. Hello. The instant petition has been filed by the petitioner complaining noise pollution created by the respondent number 9 in its workshop, resulting in affecting the right to life of the petitioner under Article 21 of the Constitution. When a matter is being taken up, sir, the counsel appearing on behalf of the Pollution Control Board is not present. And in his absence, the instant proceedings cannot be proceeded with. So taking into account the above, this court therefore directs the registry to forward the instant petition, a copy of this order to the Chairman, State Pollution Control Board. Isn't it the State Pollution Control? To be either present in the court on litigate 27. 25th. 20. On 26th at 10:30 a.m. or appoint a fresh counsel to represent the pollution control board. Pusto. This order, the order, this court is compelled to pass this order, taking into account that in the absence of the counsel appearing on behalf of the respondent numbers 1 to 4, comma, adjudication of the instant proceedings is not, would not be in the interest of justice. Pusto. This court also is of the opinion that the delay in disposal of the writ petition would be keeping in abeyance, would amount to continuing, would amount to disposal of a proceedings wherein the petitioner has claimed right to life, has claimed that his right to life has been affected.
Apply.
Professor.
Item 5 to 7.
May I please your lordship, my lord? Here, my lord, the petitioner has executed the work, my lord. All the petitioner, my lord. To my lord, ancillary work, my lord, in LPG bottling plant, my lord. Just like my lord, erection of shade, my lord, excavation, my palm, etc., my lord, and coloring and other etc. What happened in the instant case, my lord? I have executed the work. My work has been completed, my lord. Defect liability period is over. I have taken the bill. Then thereafter, my lord, they have, my lord, when I take the bill, my lord, joint verification was done, my lord. And as per joint verification, bill has been raised and bill has been paid, my lord. After the defect liability period has been over, because work has been completed in 2022, 21 defect liability period over. Then after 3 years, my lord, behind the back of the petitioner, my lord, they have, my lord, measured the, my lord, work. And they say that I have executed some work, my lord, which is not, my lord, as per an schedule of work, my lord. And I am working extra work, my lord. My contention before your lordship is that because, my lord, before taking any stigmatic view against me, my lord, they have to give me hearing, my lord. That is the law, my lord. And I am asking, when they have issued show cause notice, I am asking some document, my lord. And I also pray that you make the joint.
Show me your so cause.
Yes, well. Page 50, it will be like, what? 51, 52, 51, 52. 51, yes, well. May I read, well? Page 51. Annex 6.
What about the service upon IOCL?
My lord, copy has been said, they have appeared earlier, my lord. Last day they appeared, my lord.
Huh?
Last day they appeared.
They appear.
Yes, my lord.
Who is the counsel?
Counsel, M. Sharma. M. Sharma.
There is no affidavit. His name has been shown in the cause list.
দেখাইছেন না স্যার স্যার দেখাইছেন SCIOC. SCIOC, that's all. Just reflected.
Name shown?
SCIOC, that's all.
So show cause has been given.
Yes, my lord. I have given reply. Your lordship, come to page 54. I want to show something, my lord. In the last second paragraph, in the entire national justice for a fair and transparent jury, we further require I should provide the following detail at the earliest. Specific depend alleged discrepancy in the measurement sheet, copies of relevant document include comprehensive measurement record, the date, time, and person present during any subsequent measure activity if conducted. Not a single document has been served to the petitioners, my lord. And my lord, I also write down in my reply, my lord, you made the joint verification, my lord. Because I have executed some work. This is the factual aspect of the matter. But my lord, national justice has been violated, my lord. They have arbitrarily exercised this power, my lord. And my lord, they have issued the holiday list directly, my lord. Because it is a stigmatic view, my lord. And my lord, that is why I could not, my lord, participated in the tender process, my lord. That is why my humble submission before your lordship, before my lord, pre-decision take place, my lord, they have to give me opportunity, my lord.
Opportunity given to you, show cause.
So, cause, but my lord, without any document, nothing.
Mr. NNB Chaudhary, your case is not this. Your case, where is the judgment you are referring? Which are the judgments you are
Yes,
referring?
my lord. And act
No,
also
no.
said,
Which are the judgments?
I am relying my lord, erosion equipment and chemical.
No, another one. What are the other judgments?
That same judgment, my lord.
Huh? That would not help you. Look into the judgment of Blue Dreamage. BLUE Dreamage. DREAMZ.
Blue remain.
Versus so and so. Reported in. Let me give it to you. This is not the sort of preparation we want. We want better preparation from you.
Yes, ma'am.
Huh?
Yes, ma'am. Person, Mr. Mama. Yes, ma'am.
Getting an old 1976 judgment.
Overloaded, overloaded, overloaded.
Overloaded. Must be the reason, must be that. Otherwise, why on earth he would do that? Must be having too many matters. Yes, 2024, 15 SCC 264.
2024, 15 SCC. Page number, hello, page number, my lord.
264.
264.
The facts involved in that case was similar to the facts involved here.
Yes, ma'am.
That is also a case of blacklisting.
Yes, ma'am.
That was a case where certain additional amount was taken, was directed to be paid. So this person claimed a particular amount of some 1 crore from the City Corporation of Kolkata. And when they asked, they put him in the blacklist. The Supreme Court says, no, you cannot. These are financial disputes which can be rendered in other procedures. You cannot take this recourse to blacklisting. Isn't it your case similar?
Yes, my lord. Actually,
Then? Yes, Mr. M. Sharma.
My lord. Just ran from court.
Why on earth you were not there when the matter is called for?
How
Or you
like-
expected that this court would not reach this matter by this time?
No, absolutely not. My
Then?
lord. There was a matter which had reached in court number 1.
Fantastic. Be there. Take
Yes.
this judgment also there and go there and wait out there and prepare the first writ appeal and do it there.
No, my lord, what has happened, my lord? What had happened is that the guidelines, the blacklisting, holiday listing guidelines, my lord, they had come into effect in 2023 of 19th of January. Thereafter, without regard to the effect of the guidelines, there was a site visit by the site inspection team of the IOCL, random checking, my lord. Thereafter, there are certain discrepancies which were found. Thereafter, the vigilance also conducted an inquiry. Here, I understand, my lord, that the ground which was taken by the petitioners is that the defect liability period was over and they could not have taken or sought any recompensation from the petitioners. In this regard, what had happened, my lord, is that certain purchase orders were issued. When inspection was carried out with respect to those purchase order and to the works which were done by the contractors, there are discrepancies found in as much as payments which were made for works were not done. That is the reason why the show cause was given to the petitioners to explain their stand, my lord.
But you can do it. You can recover that amount.
My lord.
You say that 2,92,000 is the amount for which you have taken additional amount.
My lord.
That's the
Yes.
dispute in one of the cases.
Yes, my lord.
If that is so,
My lord.
it's a dispute as regards money.
Money.
If that is an excess amount, whether he pays or not, that's a, yeah, but how do you blacklist him? It is a dispute pertaining to certain amount. The law is well settled by the judgment which Mr. NNB Chaudhary has failed to produce.
My lord,
This court has to help him out.
my lord, we, the IOCL, my lord.
You have no case.
No,
I think we set aside this. You do conduct a step, take steps. You cannot resort to this is what you call twisting somebody's hand and taking out the recourse and getting the money. You want that money, you have put not only 2,92,000, additional 42,000 and say that you are blacklisted for 1 year.
no. My lord, the terms, my lord, holiday listing is not an arbitrary decision that can be taken by the IOCL.
If
bereft
the
of-
period of the work is over,
the period of the work is long over, my lord.
was long over, and then you make a why on earth you did not take any action against those officers who gave him a clean sheet?
My lord, we had terminated the services, my lord. The records are with me. The affidavit has not been filed.
Why you have not filed the affidavit?
My lord, because there was a fourth item which was listed yesterday, BK construction, which is not a part of these three matters. It pertains to the same issue same issue. Here, my lord, before your lordship asked 5, 6, and 7, creation, Edison, and Rhino. There was a fourth contractor, my lord, by the name of BK Constructions, whose affidavit was filed yesterday, and the reply was also filed by the petitioner therein. The matters were fixed on 5/3. So we could not have time to. We have gotten an instruction, my lord, and we can satisfy this court as to why the actions were.
No, we are
taken.
concerned with the blacklisting.
The holiday-
Blacklisting
My
every
lord-
day is a debt, is a word used by the Supreme Court is a civil debt. In paragraph number
35, my lord. The division of the
No, my lord,
blacklisting is a
The
business.
decision to
by
holiday list, my
the
lord.
party affected. Paragraph 35, my lord.
read from 34 also.
34, my lord. The division, in our opinion, not appreciated the case in a proper perspective, merely saying that blacklisting of the case reason is not good enough. Do the reason justifying the invocation of penalty by blacklisting is penalty proportionate was the real question. The division bench has observed that the blacklisting is a business decision by which the party affected the breach of decide not to enter into any contract relationship with party committing the breach. It is observed that between the two private parties, the right to take any such decision is absolute, untrammeled by constraint whatsoever. The observation are too sweeping in their ambit, wholly overlook the fact that respondent corporation is statutory vested with the body public function. It is not the private party. Any decision to blacklist should be strictly parameter of law, has to be principle of proportionality. A proportionality. The issue has been framed. And one thing is that he said impugn order has been used by the following the guideline of that 2023. And now he said that was not given effect to Milo.
What was that?
I do miss 119. Huh? Good. The proportionality is something that I answer. It was very instructions. I'm going to be happy husband now.
Paragraph 26.
Yes, ma'am.
25 and 26.
To readily invoke a department ordinarily case of breach of contract where there is a bona fide dispute is not permissible. Each case, no doubt, would turn on fact and circumstances thereto. Examining the fact of the case, the perspective, we find that the appellant after the award of the tender has admittedly paid an amount so and so according to the corporation outstanding amount as on the date department was on so and so. However, as would clear from the fact discussing herever, right the inception, there has been issues between the appellant and the corporation with regard to the fulfillment. of the-
Read it. In other words,
In other words,
where the case is of an ordinary breach of contract and the explanation offered by the persons concerned raises a bona fide dispute, blacklisting / debarment as a penalty ought not to be resorted to. Debarring a person abate for a certain number of years tantamounts to civil debt, inasmuch as the said person is commercially ostracized, resulting in serious consequences for person and those who are employed by him. To readily invoking the debarment for ordinary cases of breach of contract where there is a bona fide dispute is not permissible. In each case, no doubt to turn on the facts. Examining the facts of this case from that perspective, we find the appellant, after the award of the tender, had admittedly paid an amount of rupees so and so through, though according to the outstanding amount as on the date of the debarment was amount. However, as would be clear from the facts discussed here, right from the inception, there has been issues between the appellant and the corporation with regard to the fulfillment of reciprocal obligations in the bid document. There has been exchange of correspondence between the parties with each side blaming the other for not performing here. While the appellant has a case with regard to the non-issuance of the work order, non-receipt of so and so, existence only of 200 or so and so, the corporation had a case that a bank guarantee was not the mode of so and so. And in the so and so, the appellant failed to furnish the name and further. Even in the order by which the appellant was debarred for a period of 5 years, the reason given is the tender notice has clearly stated that the street holdings in the annexure would be allotted as is where is basis. So therefore, the question is, when there is a bona fide dispute
that's all.
as regards the entitlement, all these things, you cannot resort to blacklisting.
Yes.
The reason is very this, it needs an adjudication. Where there is no bona fide dispute, if it is just it's a sham dispute being raised, you can very well take it up. But the moment it is a bona fide dispute, whether in the case, because here is a case where he has done the work, completed, you find it, everything done, okay. One fine morning, you go out there after the period of completion is over, you go there and find out and say, oh, these are the extra works he has not done. He has not done, and as such, an excess payment of 2,92,000 has been taken from us. Therefore, we debar him. That cannot be a ground. Matter over.
My lord,
No
the
need to file affidavit.
my lord, deduction has not happened, and we just like to.
No, you have blacklisted.
No, we have held it, my lord, for a period of 1 year. For a period of 1 year, and our actions, my lord, were based on our own circulars, my lord. So we have not erred, my lord. We have not taken a step without having taken out the due diligence on our part. If I may permit it to produce some records, my lord, before your lordship.
Please.
My lord. Just to substantiate as to why we did what we did, my lord. Dada.
No. This is not what you do.
My lord, the action which
This
was,
goes against the judgment in blue.
my lord, the action which was
I think
initiated,
we set aside this.
have taken steps against our employees also, my lord. We have
Very
ta-
good.
My lord, we have done that because,
Very good. You have taken all good steps.
my lord, there are certain,
But the fact remains.
my lord,
You say that there was an excess payment.
my lord.
Why didn't you ask him the money? If there is an excess payment, as we could find out, kindly pay us. They would have not paid. Then it's a different thing. You say that there is an excess payment being made to you. And if this is excess payment, it is a fraud committed by you. And as such, why we should not blacklist, and we immediately blacklisted him by show cause, and you have issued a show cause. He asks for certain documents which you say that you are not going to give, and then you pass with the order. This is not done.
But last time he submitted, the money has already been recovered.
No, no. What has happened, my lord, in the there's an application, my lord, in the IUCL. The money has been recovered because there is apparently a recovery amount which has been posted in the application called SAP. Now, as and when there are future instances of being payment made to the petitioner by the IUCL, that amount will be adjusted accordingly. That is what the instruction I have as per the last occasion the matter was taken up. And the action, my lord, that you have taken of holiday listing, since your lordship is on that issue of holiday listing and also
No, you
recovering the
cannot
amount.
go for this holiday listing business. It's a very difficult thing. In view of this judgment,
My lord,
although Mr. NNB Chaudhary didn't produce.
in fact, our defense would be here.
Your defense, you don't have a defense.
No, my lord, because we proceeded on the aspect.
No,
of
no, this
certain-
is arm twisting. The right word is arm twisting. 2,92,000, you recover it also. And the best part is, now we put you also arm twisting, 1 year you don't do it. And next time onwards, you have to learn that don't take any additional money, even if it is certified by IOCL, because there are some officers higher than the above who would look into it and say this. This is not law. This is not a function of a state to do it in this manner.
My lord, your lordship is very correct, but the state was guided by a document which guided its actions, my lord. I can
No,
satisfy
it's
this.
fraud. Yes, it is a
Yes.
case of fraud being committed.
My lord.
He has taken some money, and this is not, he has signed, something has been signed out there by those officers concerned in this manner. Then it's a different aspect of the matter. You may go for, it's a fraud being committed. This is not a case of fraud. Your basic thing that there is an excess payment. Kindly see your
My lord.
show cause notice.
My lord.
Kindly see page 51. However, during a recent verification, inspection of the quantities executed under these jobs, it has been observed that quantities billed is more than the actual quantity executed for both the POs, and extra additional items were executed. It is not that he has not executed,
My lord.
which were not included in the PO.
My lord.
Now he says in his reply that, look here, I have been asked by the officer in charge to do it.
My lord.
Rightly or wrongly, that's a dispute.
That's a dispute, my lord.
That's a dispute.
That's a dispute.
Then how can you go for blacklisting in view of this judgment? Right? I thought IOCL was better than most of the others, but they also are in the same league.
My lord, actually, we are guided by certain documents which might be. might
No,
not
you
stand
may be
superior to
guided.
the law.
We go as per your show cause.
My lord.
Why should we look into all
My lord.
other things? Your show cause says that, look here, we on verification, we found that he has put up a poll, which we never asked them in the end, he has taken the money. He says that, look here, I put out the poll out there because the officer in charge asked me to put that poll.
My lord.
And therefore I asked for the money and it was cleared and given to me. And then you say that, oh, no, that cannot happen like this. Apart from that, he has asked for certain documents. You have not resort to all these things. Let us say that, no, this is all wrong which has happened. That person, officer in charge, whether inquiry was made or not, I'm not concerned to the effect. This is an excess payment which you have taken, but you have done some work, but you have taken excess payment. Excess payment because for that work where it is not included in the PO. That's it.
That's it. And
To
also,
the both
also,
side dispute, you have to ask them.
and also, my lord, also, if I may be permitted, because I also sought instructions in this matter, my lord. The reason being, a PO limit, my lord, as I've been made to understand by the client, a PO limit is the maximum outer limit beyond which or below which a deviation approval is taken, my lord. That the entire amount of, say, 10 rupees, my lord, it might not be exhausted with the entire 10 rupees.
Is
and-
it mentioned out there in tender documents
My lord.
that the PO limit is that
No,
much?
no, my lord.
Then
No, my lord.
you have not informed him. We do one thing.
My lord.
I give you 7 days time to file your affidavit. Because this is the final opportunity, because it's a case of blacklisting.
My lord.
7 days time to file your affidavit. Give him another 7 days. Then we take up the matter for final disposal.
My lord.
Till then, impugn order may be stayed.
What impugn order? How can we stand this, stop this? The person has died out there and then you say that, okay, make him alive. Thing like you putting him in ventilators. And you have not come up with the judgment. You have come with Eurasian.
Yes, my lord.
Eurasian is not, Eurasian is so-called notice. But this is the issue is whether there is a bona fide dispute or not. Once there is a bona fide dispute, you cannot go for blacklisting. Heard Mr. N.N.B. Chaudhary, the learned counsel, appearing on behalf of the petitioner. Mr. M. Sharma appears on behalf of the IOCL. Mr. B. Chakraborty appears on behalf of the Union of India. The petitioner herein has approached this court being aggrieved by the order dated 22/1/2026 by which the petitioner was blacklisted, was put in the holiday list. Pusto. Mr. N.N.B. Chaudhary, learned counsel, appearing on behalf of the petitioner, submitted that the dispute which is sought to be raised by way of the show cause proceedings leading to the impugned communication dated 22/1/2026 is a completely fictitious cause of action. In order to arm twist the petitioner. The learned counsel further submitted that even assuming for argument's sake, although not admitting, that there was any excess payment made to the petitioner for certain works which were beyond the PO, it would at best be a bona fide dispute between the petitioner as well as the respondent IOCL. Referring to the judgment of the Supreme Court in the case of Blue Remake Advertising Private Limited versus Kolkata Municipal Corporation and others reported in 2024, 15 SCC page 294. The learned counsel submitted that if there is a bona fide dispute, it is not permissible on the part of the respondent authorities to blacklist the petitioner. It is noticed that though notice was issued by this court on 13/2/2026, making it returnable on today, in view of the urgency expressed by the petitioner that putting the petitioner in the holiday list amounts to a civil debt. No affidavit has been filed by the respondent IOCL. Mr. M. Sharma, appearing on behalf of the respondent IOCL, submits that within 7 days such affidavit would be filed. Taking into account the above, the affidavit, this court grants an opportunity, grants an opportunity to the respondent of IOCL to file the affidavit on or before
Second, no?
5th of March 2026. Petitioner given liberty to file the reply by 11th of March 2026. List the matter on 12th of March 2026. It is observed that in the circumstance no affidavit is being filed by the respondent authorities within the time so permitted. This court shall decide if no affidavit has been filed by the respondent authorities, IOCL, this court shall decide the instant petition on the basis of the existing pleadings on the next date. It is further observed that in the circumstance, this court is not in a position to dispose of the writ petition and attempt, this court shall consider whether there is a necessity to pass any interim orders. List according. Let it be on another day, 12th, 17th. 17th. I won't be there.
6, 7, 7.
17th. All the three matters, same order? Same order of the
Amount is different, my lord.
amount,
Yes, my lord.
the order is same, date of the order?
Date of order is
22,
also same.
22, 22 1.
22.
May I please your lordship? My lord, I am appealing for the content petitioners, all the 9 petitioners. my lord. Out of them, 6 were sellers and 3 were buyers. 1 to 6 are the last order for, my lord, we applied for the NOC on 3/5 and 8/5/2024, my lord.
Let me see what is the order you are filing. It has been said, it is now the obligation of the designated public servant to consider the application submitted by for notified service, the proviso of so and so as amended by the registration and thereafter to pass a speaking order within a period of 3 weeks, weekdays, 3 weekdays from the date of, what is this 3 weekdays?
My lord, from the date of submission, perhaps we have submitted on
Now, what do you mean by the word term 3 weekdays?
21 days, maybe, my lord.
No, no. Did,
3 weeks, Malad. We read it as 3 weeks. Malad. Days possibly is not required.
3 weeks,
From
my
the
lord,
date-
yes is there.
huh?
3 weeks, yes is there, my lord. That's why we took it 3 weeks, my lord.
But in the colloquial, what do you call, English, this would be understood as 3 working days in the week. Weekdays. Anyways, 3, you have both understood to be 21 days
Lordship.
from the date of submission of the demand and by the petitioner at the office of the designated year. Then what happened?
Then, my lord, we have submitted in on 15/5/25, my lord. Kindly see the annexure, my lord. We have submitted it on 15/5/25 and the some memo number, file number is also there, my lord. Then, my lord,
You submitted on 17/5.
that on 2 occasions we have filed, maybe, my lord.
Docket is 17/5.
Yeah, my lord. This file number is also there and all.
Okay, then
Then, my lord, nothing happened till date, my lord.
No,
And 6 of them, my lord, 2 of them.
now
are-
the question is, have you disposed it of?
Yes, Malad.
Where is
Dispositive of, Malad, I have placed the instruction. I have also shown it to my friend. Malad, the
Sometime the
designated officer is the circle officer.
Yes, the report of the man of the home and first part of the mention and the examiner. With the buyer of the supplier, seller of the above mentioned application. Nemo must be which is in the
But then ADC directed the circle officer to.
So
pass
the reason why you are not doing it,
Kindly
what is the stamp duty?
kindly come to the speaking order, Malad. The second last page.
Huh?
Second last page is the speaking order. Ultimately, ADC has directed the circle officer to pass the speaking order. On
Okay.
2nd of February 2026, circle officer has given the speaking order.
Submitted in the mail,
Yes.
it is found that the name of alia which is mentioned in the affidavit does not match with the buyer and seller. Whether the applicant did not submit the non-insurance certificate.
And this has been served next week, my lord.
Affidavit, what affidavit?
In support of their application, they have to submit affidavits.
What is the affidavit?
In support of the applications, my lord, sale permission, NOC, they have prayed for NOC. In support of that,
So it is not by the buyer or seller.
name doesn't match.
My lord, it is quite incorrect, my lord. Earlier, they have, in the order it is mentioned, my lord. They said just it is rejected, nothing was there. My lord,
Now they have given
we have
reason.
annexed all the
Where is your
copies of-
application?
copies of the affidavit, my lord, in the,
Huh?
we have annexed all the copies of the affidavits also in the writ petition also. They have no such issue was raised earlier, my lord.
Chalo.
One thing, my lord, kindly see, my lord. The
Okay.
last page, my lord.
Don't worry, Mr. Talukdar. This court is aware what to be done. Don't worry. We'll take care of it.
My lord, the
You produce
copy,
the records.
copy has been served on them.
You produce the records of this affidavits. What to have, produce the records with.
My lord, in fact, my lord, the direction of the honorable court is to pass the speaking order. That has been passed. If he has any grievance, my lord, my respectful submission is he can challenge the order, my lord, speaking order, my lord.
Are you saying that you are not going to produce the
No, no.
records?
No, my lord.
No, are you saying that?
No. If
Produce the records. We want to see the records by next month, next Tuesday. Good stuff.
Is shown in February, my lord, past, in place of 3 weeks. And submitted in May, my lord. They are showing it 3 weeks after February and that without date, my lord. Kindly
No.
see the last 2 pages without date. No date, nothing.
No,
Last
for-
2 pages kindly see.
forwarding letter is there, my lord, 2nd of
Kindly
February.
see the last 2 pages like Leonard Wade has shown me just now. There is no date and time. my lord.
They have, he
Neither
admits.
issuing date nor serving date. But there is also one person. There are 3 petitioners, 3 separate NOCs, 3 separate applications, only applications filed together. They have served saying that only one, N. Ahmed something. This is also given to some third person, not to me or the petition.
Anjana Day has received last page for all of them.
In dateless, timeless, my lord.
My friend has accepted that
They
he
appear
has
that
received some
technically they
document.
have made it all. my lord.
Okay. This. It has been submitted by Mr. Dinath appearing on behalf of
The respondent number 2.
the respondent number 2 that the speaking order have been passed by the designated public servant as directed by the order passed by this court dated 5/5/2025 in WPC number 1493/2025. It is pertinent to take note of that at paragraph number 33 of the judgment passed by the learned coordinate bench, it is specifically directed that the said order should be passed within 3 weekdays from the date of submission of the copy of the order by the petitioner at the office of the designated public servant. It is seen that the copy of the order dated 5/5/2025 was served in the month of May 2025.
Submitted.
Was served. You want the change of the language?
No, my lord. No,
Then-
sorry, my lord.
Was served in the month of May 2025. However, the speaking order, a copy of the speaking order has been placed before this court, which is undated. Full stop. It is the opinion of this court that the said speaking order, as well as the reference made to the affidavits in the speaking order, be placed by way of an affidavit to be filed by the respondent number 2. Pusto. List this matter again on 5th of March 2026. Affidavit be filed by 2nd of March 2026.
But only one thing, Lordship, may kindly see. The speaking order by a forwarding letter dated 2nd of February, the circle officer has given us the speaking order. I have given that letter, my lord.
This is not, you don't pass a speaking order like that.
That's true, that's, but the speaking.
He
order-
also knows, I also know. You file your affidavit. We'll see along with the affidavit which has been mentioned.
Lordship.
Along with the copy of the affidavit referred to in the speaking order,
Ma-
petitioner given liberty to file an application, additional affidavit bringing on record the application so filed by the petitioner. Along with the required document, along with the documents. Yes, what is this?
Yes, Lordship, as per the office noted Lordship, as per the office noted Lordship, the response number 7 has not been received Lordship, the order item. So Lordship, I have the sharp copy Lordship, to the learned counsel, Mr. R. Pujari on behalf of the finance department Lordship. I have some searched the copy Lordship, 11/2/2020.
Steps upon response number 7 is not complete. What is your case?
Is Lordship regarding the land acquisition Lordship,
Huh?
land acquisition matter Lordship. Herein the petitioner land was acquired by the respondent authority Lordship, the water resource department in the year 2001.
Respondent number 7, why is it required to be sent by Lozima and all these things?
So Lordship, the matter was listed to Lodging Lordship, so in advance.
Why?
On the service not complete the response number 7 Lordship, the finance department Lordship.
So finance of, we have finance council.
Rajit, Finance council.
Huh?
Rajit for Pujari Lordship. So I
Where?
have served the copy Lordship, 2 copy of your serve. Another copy last preparation Lordship, 11/2/2020.
Okay. Finance, any counsel from finance? Okay. Mr. S, he will appear, D Nath. Will accept notice on behalf of respondent number 7.
No.
Taking into account, are you not the senior government advocate?
I am, my lord.
When you are the senior government advocate, you have the power over all
No,
departments.
that's true.
And if
but-
the finance council is not present, fight over, not necessary.
My,
I follow, that is my procedure.
the learned friend
These
has-
notices are, you have made up a system of the notice to be given to the standing council. Not, this is nothing to do with me. For us, you are the main person
Ma'am.
in the department, in the government. Finance council is different. First comes the advocate general, second comes the senior advocate, senior government advocate. Rest are under you, even the additional advocate general, in the status.
Ma'am.
Are you not the DDO, drawing and disbursing officer? Then,
Ma'am.
and who is the main person? Advocate general. So these are the two. Additional senior advocate general, these are all, what do you call, decorated. It is something like a building being made and some beautification being carried out. It's otherwise it has the trappings of an additional senior government advocate. Yes or no? He will take. Okay, now what is your case?
So Lordship, the matter regarding Lordship, the land acquisition Lordship. So herein Lordship, the petitioner land was acquired in the year 2001. Lord,
What?
by the water resource department in regard to the flood control Lordship.
Should not be directed to disburse the total principal amount by way of interest with a term of so and so and so and so, and also calculate so and so.
My lord, I have received instructions on behalf of the DC. We'd like to file an affidavit in the matter. In fact, my lord, in respect of the same LA case, one case, lordship has already passed an order. Here, this
Is
is
that the old person?
old person. That's
How many cases you have filed?
my lord, in fact,
I was told by somebody that you got a cost of 25,000 in this imposed upon you.
No.
Is in the same case?
I'm not aware. my lord.
Another-
Yes, something like, is that the own person? 84 lakhs.
Absolutely.
84
Yes,
lakhs.
yes, yes.
Is
But
that the
it-
case?
Same allegation.
That is the case, that judgment has been relied here.
Yes,
But
I
in
am
fact-
told by Justice Sanjay Mehdi has imposed a cost of 25,000.
I'm
Yes.
not, I'm not aware of
He
that.
filed an appeal. It is the talk of the town. What has happened? What he has done? Is this the same case?
Well, in fact, what
No,
has
no,
happened
this is
here,
not the same thing.
No,
Let's see the affidavit. Wait.
page 45,
We impose another cost of another now 25, we make it 50. Oh, this is 67. That is another 84.
page 45, my lord.
Huh?
Page 45 is the order Lordship has passed earlier in the other case.
Oh, yeah, this is different. This is Assaruddin Ahmed. This is the person who got 84 lakhs, if I'm not wrong. Let's see.
Well, in fact, that 84 lakhs,
Hmm.
my record shows, well, now I have received entire records. That 86 lakhs rupees was for the entire LA case for 127%.
Ah.
And the Asiruddin, he is one of them, having only 4 bighas of land. He has taken the entire amount.
Then what happened? What
The
is this case? This is another case. The instant petitioner, 74-year-old person being aggrieved by the action in taking over the plot belonging to the and not paying the compensation which is entitled for the law and it disappeared. That the petitioner was disappeared by the respondent 20 years back in dispossessed. And the so-and-so Niman submits the so-and-so had submitted the proposal only 20 days from today from the Water Resource Department. So we have if anyone submits the sale upon receipt could be considered by the Finance Department which may the possession of the land by emergency whether was taken from the within the year till date not a single penny was paid to so-and-so. Perusal of demand or stipulate subsequently both the land and the right to fair compensation interest were all. And 15 is not known on to whether the sale interest has been calculated at the proposal for the which who would be responsible for a fix the matter that law will be starting month. Then RC does the particularly on the demand taking into account that will be at liberty to file an application. For 86 lakhs, he got it.
Yes, yes.
And then he filed section 12.
Yes, Lord.
Then
State case was pending before the district judge and Mongol Lordship
fantastic.
for the interest Lordship. So Lordship hearing in this case.
Now what is your case here?
So Lordship hearing in this case Lordship. So the land measuring 1 kata 18 lakhs Lordship. The same LA case Lordship. The LA case number 6 of the 2021.
To disburse the
Lordship.
principal. When?
So in the year of 2001 Lordship.
And why are you approaching this court now?
So Lordship, the lots of the representation submitted by the concerned
When?
petitioner Lordship. So 2024, 2009, 13, 18 and 25 Lordship.
Huh?
So page number so Lordship 58 to 77 Lordship. The 5 number representation submitted Lordship.
And then
So Lordship, the department has not been provided any kind of the.
these were submitted. How do we know? How do we know that these were submitted? Where are the receipts?
So Lordship, kindly see.
Where are the
Page-
receipts?
Page 52 Lordship.
Huh?
Page 52.
Where are the receipts of Annexure 7, Annexure 8? Where are the receipts?
Copy is-
And why you are asking the PWD to make the payment?
So
Huh?
receipt copy is submitted Lordship.
What is this? These are all being done after 5 years also it is same. Where are the original documents?
So the
Huh?
petitioner name has been reflecting the gazette notification Lordship.
Where are the original documents? You have somebody has certified it to be true copy. Where are the original documents?
Original documents, its name is reflecting the gazette notification.
Mr. Counsel, where are the original documents? You have said it to be certified to be true copy. Where is this person? Habibur Rahman, the advocate. You are there.
Yes, my friend.
You are Habibur Rahman. Have you seen the original of these documents? Have you seen the originals of these documents?
Yes, no, thank
Where is this? Produce it. You have seen it? Produce it. Let him produce it. Because he cannot be 2004 onwards. This has happened. There are so many enclosures. Let him produce it. He says that he has seen it. Else we take action for certifying it to be true copy. If it is a fake document. The petitioner herein has approached this court after a period of 24 years since the date the petitioner alleges that his land was acquired by the respondent authorities. It is seen that from Annexure Roman 7, Roman 8, and Roman 9 of the writ petition that these documents, these are all type copies of certain representations. From the said documents, it is not clear as to whether these representations were actually served upon the officials to whom it is being addressed. This court, during the course of the hearing, also inquired with Mr. Habibur Rahman, the counsel who had certified these documents to be true copies, as to whether he has seen these documents prior to typing it out. The learned counsel submitted that he has seen these documents. Under such circumstances, let this matter be listed again on 9th of March 2026. The petitioners are directed to produce the originals of annexures 7, 8, 9, ten, and 11. 11 lega sudi. By filing an additional affidavit. Pusto. The registry shall not insist on type copies of the said documents upon such affidavit being filed, as this court had only sought for the originals of these documents. The petitioner is also directed to produce the receipts pertaining to these enclosures. Receipts provided by the concerned respondent authorities to whom these representations were submitted. This court also duly takes note of the office note, wherein it is said the service upon the respondent number 7 is not complete. It is relevant to take note of that the respondent number 7 is the Commissioner and Secretary to the Government of Assam Finance Department. Though this department has standing counsels, but as they have not appeared, the learned senior, Mr. Dina, the learned senior government advocate, would be authorized to accept an additional copy for and on behalf of the respondent number 7. The counsel for the petitioner is directed to serve by tomorrow an additional copy, an extra copy of the writ petition to Mr. D. Nath.
Lordship, with due respect, Lordship, so the petitioner, is it about Lordship the 6 to 7 years, Lordship?
So what?
Lordship, so concern is not.
If he can,
Is it-
during his prime time, when the land was taken, he didn't do anything. When he became 67, he has now. Where is the original documents? Produce it. We'll see when the matter is there. Be careful. Don't file this type of matters before this court. If you don't have, now also you have a time to withdraw. I'm telling you, give you a chance before I sign this order.
Submit, Lordship. We do additional affidavit, Lordship.
What?
So as per the direction, Lordship, we submit the.
Huh?
As per the direction, Lordship, submit the original. Yes. Master.
May it please, my lords. My lords, as per the last order, my lords,
Hmm.
these matters were directed to be taken up at 2, my lords. The cause list does not show that these matters are fixed at 2. But the
Okay.
officials could not make it, my lords, being under the impression that they will be taken up at 2. But may I pray that it can be some accommodation may be given, my lords.
Do I have another set of matters, 3 matters which I'll dispose of, then only I can take these matters, not prior to that.
My lords, as per my
This
lord,
case is to be dismissed. He has a good case. Your case is bad. KP Pathak has a good case.
My lord, in that case, may it be taken up on next Thursday, my lord?
Why?
My lord, 2 meters already have fixed at 2 meters.
Huh?
Only 2 meters is fixed, my lord. At
Whose
2.
matter? I
No,
have
other-
fixed.
Yes.
Yes,
court-
there's not 2 matters, 3 matters. So those 3 matters I have already formed up my mind. I'll dictate the order then. It won't take much time. It is only a very small issue involved. Should I tell you the issue?
deeply obliged.
Gauhati tea warehousing area. What is this? Who appears Gauhati tea warehousing?
Kindly the matter be passed over for time being.
Why?
But my senior is on the way.
Huh?
My senior is on the way.
Where is she? Hello, none appears on behalf of the petitioner as well as the respondent when the matter is called. Accordingly, list the matter. Up to 4 weeks.
May I please, Lordship?
Yes.
Lordship, matter may be passed over for time being, Lordship. My senior is on like an
Let us
Uh,
hear him.
Lordship.
If your senior's presence is not required, well and fine, I put your name. If your senior's presence is required, I
Right.
find that he has a good case. Then by that time, I think he will come.
Lordship, he is in the Kate, Lordship. He's attending matter in the Kate, yeah, Lordship.
Where is he?
Kate Central Administrative Tribunal, Lordship.
Fantastic. Okay, let us, Mr. Pade, argue. What is this?
In this case, what happened, Your Lordship, land of the petitioners are acquired. And
What order has been challenged before the district judge?
district judge arbitration are all,
How? Oh, they're under 34.
yes.
Then what are you challenging here?
In this case, Your Lordship, there are many persons. that-
Setting aside the letter dated demand and thereupon retire to immediately release. Let us see the order of 2311, 2018. Where is that? 23/1/2018,
19/4/2012,
page
8. Yes,
8,
page 33.
30.
3. Order of the commissioner, not for some, the arbitrator order.
You are challenging this order. 20, no, I am concerned with 23/1/2018. Where is that order? You are challenging which order, letter?
Page 55.
Show me that. Okay, proposal for amendment to the additional amount. When one restricted that although the honorable district has fixed the rate of enhancement of demand in the ward numbers when there is no indication of extending the scope of enhancement to other persons as per the honorable district order. Moreover, the arbitration award. Order of students mention the name of Sri Bhima person by their others. But there was not any other names. Except some Chetri. But it the land compensation. Yes, what is wrong with this order?
In this case, what happened, Your Lordship? In this case, we.
Can you use your mic? There's some problem? Yes.
In this case, our land was acquired by National Highway. And the Kala Administrative Authority has fixed the compensation rupees 1 lakh per biga land value. We have filed, after that, we have filed an application before the arbitrator, that is the commissioner. And the commissioner has passed the order fixing the 15 lakhs. 15 lakhs per biga.
15 lakhs by the
Yes.
commissioner.
Yes, by the commissioner. After that, National Highway Authority has challenged the
Award.
award. In this order of the award, there is no mention about the name of the petitioners, entire petitioners. Only one name is there, page 33, Your Lordship.
Okay. Bhim
Bhim
Prasad
Upadhyay,
Upadhyay.
others. The others' name was not mentioned here.
Then
On that strength, the National Highway challenged this order, only including the Bhim Prasad Upadhyay. And the district judge has passed this order, reducing the compensation amount to the rupees 5 lakhs.
then
Page 35, district judge order.
Ah.
Then as there is no name of other petitioners whose land was acquired, they National Highway Authority says that that is not permissible because in this order only the name of Bhim Prasad Upadhyay is there. So they have paid the awarded amount at the rate of rupees 5 lakhs per biga
two.
to the Bhim Prasad Upadhyay. Mane legal heir of the Bhim Prasad Upadhyay. In the meantime, he expired. After that, we have filed a representation to the deputy commissioner.
Yes.
Is the first representation is page 39.
Yes.
I have the honor to file a case before this honorable commissioner not going to seeking compensation for acquisition of land for our landlord accordingly in connection with the order by number 4, 2000.
So you want as per, you want 5 lakhs per week.
Yes, I want 5. We want 5 lakhs.
Now they have not paid that.
No,
Why?
they have not paid because in the order of the commissioner, no name is there. Our name is not mentioned.
But you filed an application.
Yes, we file application.
Where is your application?
This is
Where is the order of the commissioner?
order of
This one, no? Let us see page 33.
yes.
In the report of the where he has suggested the land being town, a fresh survey has been done at the present rate, and he has also referred the government so and so, so and so, so and so. Chairman also submitted during the spot inquiry of so and so, and members of the other public in the premises of area within the degree his survey of land, building and have begun because now. Now, what is the final arbitration judgment?
5 lakhs fixed. 5 lakhs fixed by the district judge.
No. Kindly see page 34.
Is 34.
It is an interim order.
Yes.
Where is the final order?
Like in the interim, there is no final order. They have challenged this order.
Now, that is a different thing,
Yes.
which is being given to them. That's a different thing.
There is no.
But there
final
has
order.
to be a final order.
There is no final order. No final order has been passed.
He has to pass the final order. And this fellow is not there,
Yes.
most probably. The commissioner, that person who has done it is no longer there. This happened in 2008. And thereupon you didn't do anything. What happened thereafter?
As per our affidavit, Lordship, the NHIA has not deposited the money. That's why we could not pay them. As per our affidavit.
I'm not on that. My question is, this is an interim order. What happened to the final order? Final order has to be passed. This is around 26 years back, 18 years back. Kindly see page 34.
This order will not affect the final arbitration judgment in any way. That is their dissent.
This is made on the basis of a assumption that from these documents, it seems that it will be 15 lakhs. So therefore, we direct 50% to be paid. And this is an order passed under 31, section 21C, read with section 31. 31 is what? Not a final award. So the arbitration proceeding is still remain.
Lordship.
Interim award.
Only because of the last line, the worship.
No, here also, if you see page 34, top also.
Yes.
On the other hand, the construction is being delayed. The appellants have applied for passing an order of interim award at 50% of the present market value, considering the probable value. So it doesn't fix the value.
Probable.
Value of the land per bigha, so and so 50% is hereby passed for the payment. So it is only 50%. It is a probable value. So he did not come to a finding as to whether the determination was right or wrong.
Wrong.
So therefore, from there has to be another proceedings.
Lordship.
This has to be culminated.
But the Bhimprasad Upadhyay has received the amount.
Now, he has got it.
Yes,
It's a different thing. But the fact remains, this has
Is
to be
not-
done.
Not yet completed.
Commissioner is yours.
Lordship.
Then-
Lordship, let me have the instruction next week, Lordship.
The whole matter.
Next week.
Best option would be to be, that means the adjudication is still not over.
Not over.
And if they had filed an application, this now, the arbitrator having died, must have died in the meantime.
Yes.
This happened in 2008, or he's no longer in service, or he's not capable of. So the arbitrator has to change,
Changed.
or by operation of law, he has to be changed. So then you have to go for a fresh award. That is the only way out. Who is your senior? See? What to do? Huh? You may get more money. Why you are settling with 5 lakhs? You get more money.
Yes.
Because therefore they have only challenged. You see, either they have to agree that, okay, we are paying only these people, because they have challenged only this award passed against somebody.
Yes.
Now, from that document, which is being given, which you are challenging, page 50, where is it? Page 55. Let us read the document. In inviting a reference to Iman, it is stated that although the Honorable Judge has fixed the rate of compensation of 225 in the ward number so-and-so area, but there is no indication of extending the scope of enhance to other persons as per the Honorable Court's order under so-and-so. So therefore, this is the reason why the other persons are not being given.
Yes.
But the challenge only was to those extent. How much land you had?
Total five bigas.
Because if you see,
Total 5 bigas land.
huh?
Out of that 1 bigas land, the compensation of 1 biga is paid. Already received the.
So therefore, this is total 6 bigas, 1 katha,
Yes.
18 lectures.
Yes.
So in this regard, he has come up to a year that this will be 15 lakhs per biga,
Yes.
isn't it?
Yes.
So it comes to 95 lakhs. So 47 lakhs has been directed.
Yes.
Now, if you go as per the interim order and make that, because this is against an interim award, and we have paid them 5 lakhs, only to them. Now, if there is no challenge, that means you are violating this order. But now your time is also gone for filing an execution.
Yes. Time is also gone.
Ah. They approach you late.
Yes.
I think you could have filed an execution against this. Because it's an arbitrary award. The moment you file that, they will be compelled to pay you 5 lakhs. They'll be happy to pay you 5 lakhs and say that, okay, settle it out. Chalo. Heard Mr. N.N. Upadhyay and his counsel appearing on behalf of the petitioner. Mr. S.S. Roy appears on behalf of the state respondents. However, no person appears on behalf, no one appears on behalf of the NHA. For 2 and 3. Argue there. Argue. Argue. If you argue, I'll put your name if you argue. Argue. How do you take care of this?
That's it. I pray for matter may be fixed at 2, Your Lordship.
Why?
My senior will appraise, Your Lordship.
Why you senior? Are you a
Lordship.
National Highway Council?
I am not the council. I am
Then
on behalf of.
none appears on behalf of the NHAI on call. The issue involved in the instant writ petition is that the petitioners herein, the land of the petitioners herein were taken were acquired under the provisions of the National Highways Act 1956. The competent authority for land acquisition had passed an award for acquiring a total plot of land of 6 biga 1 katha 18 lechas. But determining the compensation at rupees 1 lakh per biga. The petitioners, along with one
Bhim Prasad file.
Bhim Prasad Upadhyay, filed applications seeking enhancement of the compensation under section 3G5 of the National Highways Act 1956. In the said proceedings, the learned arbitrator passed an interim award on 25/9/2008, thereby opining that the value of the land per bigha should be rupees 15 lakhs. And accordingly, the total compensation payable for the entire plot of land of 6 bighas, 1 katha, 18 lecha was 95 lakh 70,000. The learned arbitrator further observed that out of the said 97 lakhs 48,000, 85,000, 97 lakhs 70,000, 95 lakhs 70,000. 47 lakhs 85,000 be paid to the claimants, and the remaining amount shall be adjudicated while finally adjudicating the arbitration proceedings. The materials on record further show that the National Highway Authority of India filed an application under Section 34 of the Arbitration and Conciliation Act challenging the award dated, the interim award dated 25/9/2008. In doing so, the award was challenged only for Bhim Prasad Upadhyay, and upon his death, his legal heirs. The learned district judge Nagaon first interfered with the award, interim award, to the extent of interim award, insofar as it relates to Bhim Prasad Upadhyay and his legal heirs. To the extent that the compensation, interim compensation, which was adjusted as rupees 15 lakhs per bigha, was reduced to rupees 5 lakhs per bigha. The grievance of the petitioners herein that they have not received a single penny in respect to their acquisition. Whereas the legal heirs of Bhim Prasad Upadhyay have already been paid their dues. Mr. N.N. Upadhyay, the learned counsel, appearing on behalf of the petitioner, submitted that the petitioners are entitled to compensation at the rate of 15 lakhs per bigha, as there is no challenge insofar as the interim award was passed for the petitioners. But under extreme pressure on account of financial constraints, the petitioner have agreed to accept rupees 5 lakhs per bigha, which the respondent authorities have not, which amount also the respondent authorities have not paid, though the land of the petitioners were duly acquired. I put it in this so that you can get 15 lakhs, because otherwise your representation will hit you.
Lordship, petitioner name is not there in the arbitration award, your Lordship.
Which award?
Arbitrary award, Your Lordship.
That is what he is saying, I am also saying. It is only Bhim Singh Upadhyay.
Lordship.
You see, the petitioner filed an application before under 3G5.
Their application is not before us, Your Lordship. So
Huh?
their application is not before us, Your Lordship, in this
Application is
case.
here, Your-
Is this not the application?
Yes.
All these people,
Page 30.
page 30,
Yes.
prayer for land valuation of the Lanka municipality. This is the land.
Yeah, yeah.
All these people.
Assume. एक number क्या है? हाँ, इन तो दुपा दो. Number 1.
This court inquired with Mr. S.S. Roy, the learned counsel appearing on behalf of the respondents, state respondents, as to what happened to those arbitration proceedings, taking into account that the state in the order dated 25/9/2008, it was categorically mentioned that it was only an interim award. The learned counsel submits that he would obtain necessary instructions in that regard. Mr. Counsel told me one thing. Do you have any copy of the land document which shows that you are the owner?
No. That we have not annexed here.
Huh?
We have not annexed here.
Bring it on record by filing an affidavit, because then it will be helpful for you, because that land has been acquired. This court further directs the respondent directs the council, you have to make the state a party. Why you're not making the state a party? This is not how you make the petition. Whom should I direct to get the records? Tell me.
Record is necessary. Record
Deputy
is necessary.
Commissioner would not have the records. The records would be with the secretary,
Secretary.
the commissioner.
Yes.
And the commissioner now being not there, it will be there
Principal
with the
secretary
secretary, so the land and revenue branch would have it. Will not make him, because the records will show that you have filed your application or not. Poorly done. Mr. So-and-so, S.S. Roy shall also take appropriate steps. It will be with the revenue department, na?
Yes, Lordship.
Yes. You are there. This court has also requests Miss So-and-so, who is the standing counsel of the revenue department of the government of Assam, to produce the records pertaining to arbitration case number 4/2008, which was earlier, which was pending before the Commissioner North Assam Division.
This too.
And presently, would be under the custody of the special secretary to huh? The Revenue and Disaster Management Department. List this matter again on 30. Yes, Mr. Siburu. Non-appears, it was going as non-appears. No, you see, Mr. Siburu,
My lord.
they say they have filed applications before the arbitrator. Arbitrator passed an award.
Yes, my lord.
It's an interim award. Now, did you pay this 5 lakhs?
Oh,
No, not to them, to this Bhim Singh Upadhyay's family, which you have paid. As per the arbitrator's award, no, as per the district judge's award, you have paid that 5 lakhs.
5 lakhs, those are names were there. We have,
Understood? You have paid these 5 lakhs in quad those persons coming under the Bhim Singh Upadhyay's case. Okay. Now, did you pay for this 6 because 1 katha 18 lectures of that? Because what was before the learned arbitrator was the 6 because 1 katha 18 lectures of that, which included many other persons also. So therefore, either you have to pay 15 lakhs
or 5 lakhs.
or 5 lakhs. That is one. Secondly, the arbitrator's award is interim, not final. So the final adjudication has to be done. And you have challenged the interim award under 34. Only this
Yes, some persons.
Bhim Prasad Upadhyay.
Hmm.
So therefore, they are otherwise entitled for 15 lakhs. So the only way out is either you culminate these proceedings, the arbitration proceedings has to come to an end. It cannot remain for all time. It is still in the air. Therefore, I've asked them to produce the records.
Yes.
Revenue. So
The-
once the records
Yes,
have been
that is
produced-
also my, I would have been submission before lordship. This record is required, everything will be clear.
I will put one submission for me.
Lordship,
Mr. C. Borua,
record may be confirmed by arbitrator.
Okay, Mr. C. Borua, the learned counsel appearing on behalf of the petition, on behalf of NHAI,
2 and 3, my lord.
submitted that the National Highway Act 1956 does not have a parameteria provisions in terms as provided under Section 28A of the Land Acquisition Act 1894. And as such, the benefit which is being granted to another person, there cannot be any redetermination of the award under the National Highways Act.
Lordship,
That is one thing to put that submission, because then it makes the dispute interesting.
yes.
It is maybe another council may get, another judge may get it, but it becomes interesting.
Well, lordship, your lordship is kind enough to call records from arbitrator.
I've called, yes. I've done that.
Yes, that's. My
Because the
submission will
records-
be the first
Huh?
that one. My submission also would have been this one, but I will, I guess somewhere lordship due this one.
No, the records.
Anyway, I'm
are
lucky
there.
to be here.
Records is
Lord-
required.
My
Because
lord, my
once
lord.
the records are there, then we can ask them
Yes,
to pass the award,
my lord.
whatever award. Then you see, I have strong reservations what the learned district judge has done. The learned district judge could not have reduced to 5 lakhs. He could have, at that point of time, the law which was prevailing then was to set aside the award
Yes. Either set aside or allowed.
or allowed.
Latest judgment also will.
Absolutely.
Yes,
It is only in exceptional circumstances, which is now the Constitution bench judgment, it is only in exceptional circumstances they can do something.
I'm not favoring the chief judge, but that time might have this judgment which was there recently has come. That was in not coming.
No.
That is why that may be
No,
that happened. I think.
Mr. You see, this judgment, not now, the judgment came earlier at that point of time. That judgment was McDormand versus Burn Standard Insurance.
Yes.
That was the judgment where I think Justice S.B. Sinha was holding the say that you cannot. You can either set aside the award or yeah, you cannot modify. This trend of decisions
Yes,
continue.
yes, sir.
It is only now, it is
Final.
made on a very limited spec you can modify.
Yes, madam, that's correct.
So this award is also wrong. At the
Yes,
end
yes,
of the
definitely.
day,
That
if
was-
these
yes.
people's land have been taken, there has to be a payment. Now the problem is, if there is a delay, it is only affecting you because interest has to be paid. Now, whatever may be, in view of Tarsan Singh, na,
Yes.
they will be entitled to interest.
No, interest part will be decided by your lordship, Denali.
Everything.
But this today we are lucky enough to get before your lordship. So then we also want to resolve this because it is getting for problem us also.
Yes, madam, when can you produce the records? 30, na?
30th.
31st of March, because you see, from 16th to 27th March, most likely I may not be here.
Election.
But I have been telling the court, the lawyers, I won't be there, and then again lend up to their to their unhappiness. Again, I am here. So therefore, the question is, I am just, that's the rumor which I have heard that I won't be there from 16 to 27 March.
Yes, we said.
You see,
Yes.
this, whatever may be, this has to be brought and channelized.
Yes, yes,
This
yes.
matter couldn't have gone
Get
so long.
get finality.
Yes,
Yes,
it
yes.
has to channelize. Once it is being channelized, ask the
Yes,
special secretary to finish it off and then complete.
Only our decision, my submission is decision, though I'm not paying for part hard and all that thing, but lordship, so this 15 lordship did that day, because your lordship has already heard this matter should be better.
Before a year, for further consideration.
My lord.
Order.
I will like
31st. So then this needs to be channelized. Once it is channelized, they will get it or
Yes,
they
yes,
may
yes.
not get it.
Sir, lordship, we are ready to pay provided this all getting clear.
Yes, sir, this has
This-
to be done because
yes.
otherwise, you say, whatever may be, possession has been taken. So therefore, the interest will run at 5 and 15%. That is a huge compulsion.
Interest will go more than principal. Interest will go more than
Yes, it will go in the principle, and luckily it is simple. If it is compounded, it would have had a more disastrous effect. But it's simple.
there is also public exchequer. If at all we are paying, there is public exchequer. Highly obliged.
Miss, name of so and so be reflected in the. Let's see. Yes, what is?
Item number 14, Lordship, I'm really sorry. I just.
Okay, we had it after 4 weeks.
Lordship,
It would be mad.
Lordship had two, Lordship, it
No,
can get.
two,
or-
I have
right?
your other 3 matters, no?
Yes, your Lordship.
Other 3 matters I have to.
Lordship, day after tomorrow also, I have informed the other side also. Day after, because it is covered, Lordship, by Bombay High Court has already decided the issue.
Oh, Bombay High Court judgment would not be binding on me.
No, your Lordship, but
So, how do I say?
Lordship, it may be
Let me
taken.
come
day-
back.
Lordship,
Okay,
Day after tomorrow, Lordship. 14.
okay, we'll see. After we'll have it. First your 3 matters, then I have a electricity matter, then I'll take it to you.
Much obliged, much,
Inform the other side.
much obliged.
Obliged.
The National Highway Act. By this order, my lord, reference court, my lord, apportionment has been made between the landowner and 2 class of tenant. And the owner is giving 25%. And one tenant, according tenant is giving, my lord, 65%. Cultivating persons is given 10%. We have sent that.
Let's see the order passed by the learned
Page 44.
page.
Page 44. Definition, there is a ownership right claimed by the tenant, that was granted. But this, especially this national.
What is your ground?
Hello. Our ground is made up during the after the land is vested to the national highway mega. There cannot be any adjudication regarding ownership right of tenant mega. Under
By the?
by the deputy commissioner. They,
Oh, Deputy Commissioner has not done that. This is done under 3H4.
no, that is in the middleman. The really proceeding is going on that. After the initiation of the notification of the eviction. The tenant filed a petition under section 2 and 53 of the 1971 Act for ownership right. That was granted. But at the relevant time, the land is not vested, the land is vested in the government already. So that is, we declared the revenue appeal, that also rejected. So
And what happened to that revenue appeal rejection?
rejection, well, we have challenged here also, along with this. They have found the order of the rejected.
So you say the ownership cannot be given under 23 and 25
After the notification of 3,
after the notification under 3D,
it's clearly vested.
3D2. Now who applied 3H4?
Ten to 50. Another group of personnel, they claim they are cultivating the land. Although they are not, there is no record as such. But that they are actually accepted by the districts and giving them 10%.
When is the notification issued? Under 3G1, 3D1? Huh?
22/7/2011.
No. 3D1 here. But what do you say that they have rights there as they are the occupancy tenants? Forget about the ownership.
They
Then,
have tenant,
so this is how the court has given. Kindly see page 59.
they are tenant. If they are tenant.
In fact, they should be sad that 10% has been taken from them. It should have been, as per the Supreme Court judgment, it is 25/75. From 25, the court did not take. You are kept with 25. But from 75, 10 has been given to somebody else.
And the tenant, if the other two is there, then they are not cultivating, then already have documented there. But they are claiming that we are cultivating.
But they have Rayati Khatian.
Party Kotian is there.
So then,
They are not, my lord, adjudicating in proper way.
but the law is clear on that. They are persons interested. In terms with the Land Acquisition Act also, they are persons interested. There's no quarrel with it. And the judgments of the Supreme Court in these two cases are also makes it very clear.
If person interested, they will only get 10%. They will get 10% as per 3(2). 3(2), they will get only 10%.
Who?
Person interested.
Where?
3(2).
Under?
3G. National Highway.
Ah.
3G.
Where the right of user, nature of easement on any of the land, they shall be paid an amount to the, there shall be paid an amount to the owner and any other person whose right of enjoyment has been affected in any manner whatsoever by reason of in an amount calculated at 10% of the amount determined under subsection. Shall be paid an amount to the owner and any other person whose right of money in any manner whatsoever by reason of such acquisition. Let's see those two judgments on which the learned court had relied upon. You are appearing for?
Or 10 to 10, 11 lordship expired, 10 to 15.
Okay, these are the judgments you are relied upon.
Yeah.
Show me. Give me a copy of this. 94 4 SCC 623 523. Order seems to be reasonable. I am in 226, not to interfere. Well, dismiss. Order is reasonable, taking into account that variety of Khatians have been issued to these people. They have they are on a different footing. They are not a right of user on that.
One of the judgment Miller, 1994 Miller, relied upon by the.
Hmm?
One of the judgment Miller, relied by the. Court Miller,
Where is it?
this Miller. When it doesn't be 25% and 75%, that is 1,340 is given on the basis of act itself. That act Miller can say provide that provision.
Let's see.
Windows. 1994 4 SCC.
तो आपसे समझा बुक लो लाइब्रेरी बुक लो
You see, the judgment in this case is different. There, that case, what you are saying about a particular provision, there it is said that he, as per 18.3, then there is a of three, at 18.3, he is liable to pay 3/4. And on the basis of that, the owner said that when the land is acquired, I should be getting 3/4. The court said no. The reason are three. First is the benefit in terms with section 21, 23 has various components. First is the value of the land as on the date of the notification. That is one. But 2 to 6 benefit is to be got by the person who is actually in possession. Secondly, the solation amount can only be by that person concerned, not by the owner, because it is not parting with him the possession. Thirdly, interest also he is entitled, not the owner. Mr. Dekar will look into this judgment 2023 19 SCC 126. This provides certain insights on this aspect.
2019, 23.
2023 19 SCC 126. Judgment by Justice Pardiwala.
We are Gavai and Justice Padiola.
Huh?
We are Gavai or JP Padiola.
Ah,
Next more and others also missed.
paragraph 28 onwards. There's a fine distinction between determining the amount to be paid towards compensation and apportionment of the amount. The legislature have thought it fit to confer powers upon the principal civil court of the year to determine the amount. The question of apportionment of compensation is not free from difficulties. In apportioning the compensation, the court has to give to each claimant the value of the interest which he has lost by compulsory acquisition. So stated, the proposition may appear simple, but it is a practical application. Numerous complicated problems arise in apportioning the compensation. The difficulty experienced is due to the nature of variety of interests, rights and claims to the land which have to be valued in terms of money. The compensation awarded for compulsory acquisition is the value of all the interests which are extinguished, and the compensation has to be distributed here. Now, if you look into 23 and 25, how much would you get? Something around, at best, 1,000 rupees. Nothing more than that. It is on the revenue. So 25% is good amount. Oh, you were there?
My lord,
What?
I'm for the private respondent, my lord.
Without you, I'm trying to fight your case. Taking into account the
75%.
your junior was
My lord.
having difficulties, so I was trying to fight your case.
My lord. I'm sorry, my lord, I was.
No, more particularly, you see, we are exercising 2 to 6. Very difficult to look into because this is although unless it is too outrageous, it becomes very difficult. Chalo, let's dictate. Oh, chalo, we dictated 2. Today. Then we'll take up their matters. These matters cannot be CV. It doesn't do like it. 2023. And then does it need to level label? No. Let's see, 523. Because Mr. P. S. Dekar, the Learned Senior Counsel, assisted by Mr. P. Bhattacharjee, appearing on behalf of the petitioners. Revenue. Mr. P. Talukdar, assisted by so-and-so, P.K. Mehdi, appears on behalf of the respondent number 2 and 3. Mr. J. I. Paulkuya appears on behalf of respondent numbers 4 to 15.
10 to 15 excluding 11, my lord. 10, 12, 13, 14 and 15.
10, 12, 13, 14, and 15.
And 15.
C. Vulva is here, na? The C. Vulva appears for respondent number 16 instead. The present with petition had been filed, challenging the order dated 30/6/2022, passed by the Learned District Judge, Gauhati, in LA case number 1/2018, whereby while adjudicating a proceedings under section 3(H)(4) of the National Highways Act 1956, for short, the Act of 1956, the compensation has been apportioned amongst the three groups, whereby the petitioners have been only been held entitled to 25% of the compensation. The materials on record show that a plot of land measuring 2 bighas, 2 katha, 19 lechas covered by Dag number 333-24/313, 25/313 under PP number 3 of Hazari Moja, Nokori, Bamungao in the district of Jorhat was acquired by the National Highway Authority under the National Highway Act, under the Act of 1956. The compensation was accordingly determined by the competent authority in terms with section 3(G)(1) of the Act of 1956. Three sets of claimants laid a claim to the compensation, as there was a dispute as regards the entitlement of the compensation. The competent authority referred the matter to the Learned District Judge, to the principal judge, the court of the Learned Principal Judge that is the learned district judge Jorhat, for an adjudication in terms with section 384 of the Act of 1956. In the backdrop of the above, it is now pertinent to take note of the respective claims as set out by the three sets of claimants. The first set of claimants, the first group of the claimants were the petitions, who admittedly were the owners of the plots of land. The second group of claimants were statutory tenants under the Assam Temporarily Settled Area Tenancy Act 1971. Who were not only cultivating the land, but their rights have also matured to claim ownership under section 23 of the Act of 1971. The third group were the second group took the third group took equilibrium. The second group of claimants were that those were those occupancy tenants but whose names were not recorded in the record of rights. The third group of claimants were statutory tenants under the Act of 1971. And by dint of their possession, were entitled to claim ownership in terms with section 23 of the Act of 1971. It is relevant to take note of at this stage that in respect to the acquisition of the land in question, the notification under section 3D of the Act of 1956 was published in the Gazette of India Extraordinary on 22/7/2011. A reading of the significance of the said notification . is that the land on the date of publication of such notification vests absolutely in the central government, free from all encumbrances. So, at this stage, it is also pertinent to take note of that while the land has already vested upon the central government by virtue of the notification issued on under section 3D1 of the Act of 1956 on 22/7/2011. The Deputy Commissioner by an order dated 23/5/2016 passed in TSA case number 17/2013 granted ownership rights under section 23 of the Act of 1971 to the second group of claimants, to the third group of the claimants. An appeal thereagainst was filed by the first group of the claimants, that is the petitioners, before the appellate forum, that is the Assam Board of Revenue. But the said appeal was dismissed. Thereby upholding the order of the Deputy Commissioner, Jorhat, in TSA case number 17/2013. Be that as it may, the learned district judge by the impugned order dated so and so apportioned the amounts, the compensation, thereby granting 25% in favor of the first group of claimants, that is the petitioner, 10% to the second group of claimants, that is the respondent numbers 4 to 10, and 65% to the third group of claimants, that is the respondent numbers 11 to 16.
To my lord.
15.
10, 12, 13, 14, 15.
So, 10 to 15. 10
My
to
lord.
15.
Excluding 11.
You are not appearing, but
My lord.
they are
Ah,
getting.
somebody.
Yeah, 10 to 15. And it took 4 to 9. Huh? It is under such circumstances the present petition has been filed. Before proceeding to adjudicate the dispute, it is pertinent to take note of that the Act of 1956, though provides that the principal civil court of original jurisdiction, within the limits of whose jurisdiction the land is situated, would be the competent court to decide a proceedings under section 3H4 of the Act of 1956. But there is no appellate provision against such orders passed in exercise of the powers under section 3H4 of the Act of 1956. And as such, the petitioners herein have approached this court under Article by invoking the extraordinary jurisdiction under Article 2 to 6 of the Constitution. The learned senior counsel appearing on behalf of the petitioner submitted that upon issuance of the notification under Section 3D2 and 3D1 of the Act of 1956, the land vests upon the central government. And under such circumstances, there could not have been a conferment of ownership upon the respondent numbers 10 to 15 by the learned deputy commissioner. By the order dated 23/5/2016, inasmuch as the land by virtue of Section 3D2 already stood vested by operation of law on 22/7/2011. The learned senior counsel submitted that this aspect was not taken into consideration in the proper perspective, and thereby granting a higher compensation to the respondent numbers 4, 10 to 15. Inasmuch as the petitioner herein, who were the owners of the land as on the date on which the land vested upon the central government, ought to have got the largest share of the compensation. The learned senior counsel, further referring to Section 3G(2) of the Act of 1956, submitted that the right of the respondent numbers 4 to 15 can at best be said to be a right of user and or a right of easement. And under such circumstances, they could not have been entitled to a compensation more than 10%, which the learned district judge, Jorhat, had failed to take into consideration. Anything else? These are the two submissions.
Yes. One thing is this, if the one group is getting 10% right of user, then the right of tenant to be crowded, because 2% cannot be user. Tenant is also, their right is tenancy right. They have to cultivate. But the other groups is claiming that they are cultivating. This is the point.
But they have been given 10%.
10%. So if it is getting 10%, they are the cultivator.
But you have not gone for cancellation as they are not in possession.
They are in
Have you gone for cancellation of the Rayati Khutian?
No, Rayati Khutian, no. We have not.
That is a problem there.
It is not. Khutian is probably, it is not in record, their ancestor is named in the army, but they are succeeded as per Tenancy Act. But whether they are a tenant, status is tenant, subsistence is not decided. Because if it is a non-cultivator, then he will not inherit the property, although
the fact that there is a
Khutian in the name of their father.
Khutian in the name of the father is there, and that Khutian is heritable.
Yes, heritable.
It is heritable. And the fact that in 2016, there was an ownership right, although it couldn't have been granted, but it was granted, means they were right.
Yes. That is
the problem, right?
Materials are not available.
Yes, anybody would like to make a submission? Or should I say that this court made all the submissions?
Yeah, my lord, from the perusal of the competent authority jurisdictional court, my lord, he has already clarified, my lord, who will get how much, my lord. So there cannot be attributed any wrong by either parties, my lord. So whatever he has projected in the judgment, my lord, elaborate judgment has been given by consulting all the relevant provisions of the law. So as such, my lord, there cannot be any wrong.
That too, I would have put it without you saying anything specific.
Apportionment was not done, considering them to be as owner of the land. They were considered as riots, so therefore apportionment was on the basis of the riotic hatia.
Mr. B.J. Talukdar, the learned senior counsel appearing on behalf of the district administration submitted that the submission made by the learned senior counsel appearing on behalf of the petitioner pertaining to section effect of the notification under section 3D2 of the Act of 1956 is misconceived in the facts of the instant case, taking into account that the learned district judge, Jorhat, while passing the order, did not take into consideration the said aspect of the matter. The learned senior counsel for the respondent district administration submitted that the learned district judge, Jorhat, had passed the order considering the third group as a riotic khatian, as a khatian holder, and not as owner. Mr. J.I. Bordhuya, the learned counsel appearing on behalf of the private respondent, submitted that a judgment so passed by the learned district judge, Jorhat, duly takes into consideration all the relevant factors necessary for adjudication of a proceedings under section 384 of the Act of 1956. And as the instant petition, as the powers of judicial review have been invoked by the petitioner, this court would not exercise its jurisdiction unless a case of perversity is being shown by the petitioners. The learned counsel for the private respondent further submitted that there is no perversity which have been shown to the impugned judge order, and as such, the question of interference by this court under Article 2 to 6 may not be resorted to. I've heard the learned counsels appearing on behalf of the petition, on behalf of the parties at length, and have also given my anxious consideration. The materials on record show that there are have also given it. This court have also perused the records which were called for by this court. The records pertaining to the proceedings before the learned district judge Jorhat, which were called for by this court. A perusal of the materials on record, as well as the records of the learned district judge, of the court of the learned district judge Jorhat, clearly shows that there were three types of claimants, three categories of claimants. The petitioners herein were the first group of claimants who claimed compensation on the basis of their ownership. The second group of claimants who were the respondent numbers 4 to 9 claimed themselves to be occupancy tenants under the Pattadas, but their names were neither entered in the record of rights nor any khatian was issued to them. The third group of claimants were who were the respondent numbers 10 to 15. Were statutory tenants under the provisions of the Act of 1971. This court finds it very pertinent to take note of that petitioners herein were not in possession of the lands in question. The possession of the lands were that of the private respondents. Under such circumstances, at this stage, this court finds it very pertinent to take note of the judgment of the Supreme Court in the case of National Highway Authority versus so-and-so, reported in 2022-15 SEC page 1, wherein the Supreme Court observed that while determining the compensation under the National Highway, under Section 3G of the National Highways Act 1956, the provisions of Section 23 to 30, 26 to 30 of the Right to Fair Compensation Act 2013 is required to be applied. Taking into account the above, taking into account that the acquisition in the instant proceedings were initiated and stood culminated prior to 1/4/2014. The provisions of Section 18 to 23 of the Land Acquisition Act 1894 has to be parametrically read with Section 3G of the Act of 1956. Under such circumstances, what transpires is the manner in which the compensation is to be determined has to be taken into account by taking into account Section 23 of the Act of 1894. Section 23 of the Act of 1894 postulates 6 parameters by which the compensation is to be determined. They are 1 to 6, firstly, secondly. It is very pertinent to take note of that as the petitioners are not in possession of the land, they cannot be held to be entitled to the parameters which come under clauses Roman 2 to Roman 6 of the Act of Section 23 of the Act of 1894. What the petitioners can be said to be entitled to is to be on the basis of a consideration made as to how much would be their entitlement in terms with clause 1 of Section 23 of the Act of 1894. That is, the value of the land as on the date of the notification under Section 4 of the Act of 1894, which will be a parameter to the value of the land as on the date of issuance of the notification under Section 3, capital A of the Act of 1956. It is also pertinent to take note of that the petitioners herein would not be entitled to any solation or any interest on delayed payment. Taking into account that the petitioners were not in possession of the land. In this regard, this court finds it very pertinent to take note of the observations of the Supreme Court in the case of Colonel Sir Harinder Singh Brar Bans Bahadur versus Bihari Lal and others, reported in 1994 4 SSC 523. Paragraph 12 and 13 of the said judgment being relevant is reproduced here in under. Next. This court also finds it also pertinent to take note of another judgment, a recent judgment of the Supreme Court in the case of Vinod Kumar and others versus District Magistrate Mao and others, reported in 2023 19 SCC 126, wherein the Supreme Court observed as to how the compensation, apportionment, how the question of apportionment of the compensation is to be decided by the court, by the competent court in terms of section 384 of the Act of 1996 and 1956. Paragraph 28 to 30 of the said judgment being relevant is reproduced here in under. In the backdrop of the above, this court duly takes note of that the learned district judge, by the in the backdrop of the above, this court also finds it pertinent to take note of the Act of 1971. The Act of 1971. And the rights so conferred upon the occupancy tenants in terms as mentioned in Chapter 3 of the Act of 1971. It is also seen that not only these occupancy tenants have been conferred by the Act of 1971 with various rights, but also a right has been conferred upon these occupancy tenants of acquisition of ownership as well as acquisition of ownership rights. This court also takes note of that if acquisition of the compensation which is required to be payable for ownership, for acquisition of ownership rights is an amount equal to 50 times the full rate of annual revenue, land revenue payable for such land. In the backdrop of the above, it would be seen that the respondent numbers 10 to 15 being occupancy tenants, they were a protected class by the Act of, as mandated under the Act of 1971. They could not be evicted. Except as provided under Chapter 10 of the Chapter 9 of the Act of 1971. It is also seen that there were no steps taken by the petitioners to take any steps for ejectment of the respondent numbers 4 to 10, respondent numbers 4 to 15, respondent number 10 to 15. At any point of time. In the backdrop of the above, if this court now takes note of the judgment, impugned judgment order dated so and so passed by the learned district judge, Jorhat, dated so and so, it appears that the learned district judge Jorhat had given due reasons as to why the petitioner have been only, the entitlement of the petitioner have been only kept at 25%, whereas the entitlement of the respondent number 10, 4 to 9 have been kept is at 10% and 10 to 15 at 65%. It is also pertinent to take note of that this court is not sitting on appeal against the said order. And since any perversity being shown or a case of gross unreasonableness, it would not be proper on the part of this court in exercise of the powers of judicial review to interfere with the impugned order dated so and so. Accordingly, this court does not find merit in the instant case for which the petition stands dismissed.
There is an interim order.
The interim order stands vacated. The registry shall forthwith return the records to the learned court of the district judge Jorhat.
May I please, Your Lordship? Lordship, today, Lordship, before Lordship showing this Lordship judgments, Lordship, I'll show some provisions of law which I missed last time. Lordship, first of all, Lordship, I would like to take your Lordship to the provisions of section 254 of the Assam Value Added Tax Act. Writing can't do.
Lordship, regarding this matter, I have been asked that let the other side finish their set of arguments first. I'm told that when it comes to the respondent taxation department, this case will be led by Mr. B. Chaudhary, who could not come to the court today because of some medical difficulties. That is why he has told me that let the other side finish and we will keep our arguments on the next occasion. 10 minutes.
Every day it's a 15,000 cost. Okay. You know it. The matter was fixed today.
Yes, sir. I mean,
Then
there was some.
you
technical-
keep on engaging whoever it is. How am I concerned with that?
Yes, sir.
Don't come up with this silly excuse. Other courts are very good, not like me. Anyway, 254.
Subclause 54, Lordship, that is taxable turnover. Taxable turnover means the turnover on which a dealer is liable to pay tax as determined after making such deductions from his gross turnover and in such manner as may be prescribed. So there are deductions which are allowed on the taxable turnover. Now, Lordship, section 11 of this act. Lordship, the taxable turnover which is there, for the purpose of this act, taxable turnover in relation to a dealer liable to pay tax on the sale of goods means that part of the dealer's gross turnover during the prescribed period which remains after deducting therefrom. Lordship, there are deductions which are prescribed under A2, A, B, C, D. We are concerned with D, Lordship. D, Lordship says the turnover of such sales or other such amount as may be prescribed. D says prescribed, Lordship.
Turnover of such other sales or such other amount
As may be prescribed. Lordship, now the prescription is given under Rule 9. Rule 9 is important, Lordship. I rely on Rule 9.
You're not manufacturer. If you are the manufacturer, you are manufacturing where? So then where is the first point of sale? You are not a wholesale. Here is the case of wholesale. No. This is not the case at all. No, you cannot say all these things. I am the manufacturer. Where have you mentioned that you are the manufacturer of the goods? Show me. Where on earth have you stated at any, you are a dealer under so-and-so escaping turnover? Where is it? Have you at any point of said that you are a manufacturer? Where? When the petitioner is a private lawyer deals in medicines in a registered and here court bill was leviable on the sales of tax and so and so. Where is the what? Then don't come up with all these things. We have nothing. We will not go into that aspect. Levy, the gist of the levy of tax on fee distributed supplied air is unlawful. Opportunity of being heard not provided. No consideration for C supply. Levy of tax on an MRP value is not supported by the Constitution. Levying of tax in not a single word stated anywhere that you are a manufacturer and now you come up with all these things. Don't come up with this. Then, next. Ah, to a doctor, it's okay. You are not selling it to the doctor, you are giving free. But you cannot give it to the retailer. You know, what trade discount? If you are given, there is also, where is that, there is an amendment also somewhere? Where? No, no, this is okay. This, you can't help it with this. No, not on this. There is also a notification to the effect. You have to produce the. There is a case where we don't get the help of the government. There's a. No, that is okay. That is what Schedule 4 on medicine, it is given out there. You can't use this. No, if it is written as free samples, it's a different thing. Discount, if it is same different thing. Now, as a discount, can you take this? Because what is happening is the discount, if then what you see the problem which is going to have. You may say that with one sample, 1 year, I give 5 free. Let's take the example. Well, finished. Only one they will get. Yeah. You cannot take that. Or out of 10, if you take 10, 7 is free. 70% off. 7 is free. So you see it out there markets.
Yes,
10 to 70% off. Means 7 is free. Out if you 10, 7 is free. So if you take 7 free, means there is no tax. Then it cannot be. Therefore, this is the amount allowed as discount provided such that is allowed in accordance with the regular practice of the dealer, or is in accordance with the terms of any contract or agreement entered into in a particular case having a bearing on the price consideration, provided the accounts show that the purchaser has paid only the sum originally charged less discount. Yes. What? Hmm. Hmm. What? Para? Where? If the state has no competency to levy an MRP, under what authority has he has provoked members of the public to pay tax? If the tax is accrued, it would remain in public money in the form of government revenue, but the money retained by the retailer is otherwise the money of the public remains in the was well aware of the fact that the goods, though at the first stage was supplied free of cost to the retailer, as promotional measure, the goods would be sold by the subsequent seller, and since the goods were inscripted with local tax, etc., as evident from his account, thereby burdening the customer to pay tax, and thus he cannot avoiding the responsibility of the tax burden by accepting a part of the scheme and avoiding the other part after invoking the path of profession, just in the dictum local.
discount, what they have written, but in returning to pay tax, we have to issue free on discount.
Where?
What they have written in one hand, he followed and paid tax on MRP. On the other hand, that is the free question. Pumped goods to the market with free instruction of local tax extra, compels the tax to pay tax, but is refraining to pay tax in the full of it is free on discount.
Then why are you putting local taxes extra?
That was a prevailing.
Put it, you should have put it not for sale.
But if,
Why didn't you? Why, you should have given it not for sale.
but if, it is the, it is written that it is free cycle, that is also written of the thing. And any local tax is extra, means that is.
There cannot be, if it is a fee sample, there cannot be. If it is put out there, that is not put. In that packet, it is not put to, just for example, which when you give it to a doctor, you say physician sample not for sale. Now here, you don't put it. Because you say that if you take 5, I'll give you 2 free.
You give it to free, and in that free is written, but if it is disclaimable of this two, we have written this. They have already accepted.
Where? Where? Huh?
Free on. From my side, it was given free on discount. If the retailer paid, I have made it very clear.
No, that is your claim. That is your fee. That is what is being meant out here. That here, this is free on discount. This is being free. They are giving it, and they are putting out their local taxes extra. The retailer is going to sell it, and also take the tax. But the tax, this person is not going to get. So what was your necessity? When you are giving the free sample, you are to therefore take only the tax. It is what you are responsible. You knew that it is the first stage. You give it on money, that's a different thing. Then it won't be taken as a kuchobia.
Even if the retailer sells, if the retailer sells that on the product, because local taxes are not included in that. Whatever I have given to the person as free of discount, the tax is not included anywhere, and that is why local tax is given that is temporarily different from normal MRP.
Then who is going to take, just for example, a normal some medicine, a normal medicine is being taken at 100 rupees with local taxes extra. How will you pay the tax?
Nothing,
You are to charge at the first point.
nothing, because I am not charging.
You have to charge. Madam, unless you charge the tax at first point, how do you pay? That means you are not turning the entire sales which you have been doing without charging tax from the retailer. Then how do you get the money?
But I am not getting the money, I am giving the free samples.
Forget about the free sample. No, forget about free sample. I am saying about the medicine which you are charging, not free.
Charging nothing is on MRP basis.
So MRP basis, are you charging the tax or not?
On that I am charging.
Therefore, therefore, when you are charging the tax upon that, here also, when you are giving the free sample, you should have only charged the tax, because the tax has to be borne. It is the loss of the state. Because of your business, can the state lose?
But nothing, that was the first point of claiming the state of account. So I am. And I, whatever section.
No, madam, that is never it. That is never your case also. The sample copy is given only to the doctor. You don't give it to the retailer, sample copy, because obviously, why will the retailer take it? Would it to store it? Popularity of the business is being given to the retailers. Then why you are not giving to the hospital free of cost? No. Then where is the case of hospitals where you are asking them? Hospitals you are not giving free of cost. You are giving it to retailers. Who is going to sell it? What do the retailers do? They just go around and give it? No. No. Not possible. I think enough. We've heard a lot. And one judgment. You give me two judgment also. I will look into it. But this cannot happen. kindly come to paragraph 6. First of all, the issue were twofold. This was not a case of precept. It was a case where certain discounts were allowed pursuant to certain agreements, and thereby categorically showing that this is the discount being allowed to. Now, this discount, the benefit of these discounts were being given to him in terms with rule 9 or whatever it is, rule 9B, 9A. So, in terms with rule 9A, these discounts were accepted it and had said that, okay, this needs to be given. And there were another case of returning of certain goods. There also those benefits should be given. So this is being excluded from the term. Now the matter went to the Supreme Court. The Supreme Court observed that paragraph number 6. What is this? Kindly see. Remember, you see, we are not inclined to accept the submission that the service discount in question is in the nature of set-off on account of reciprocal promises or amounts into consideration for an agreement styled as trading. Trading contracts are those where goods are transferred by the seller for consideration partly in money and partly in exchange of some goods to be sold by the buyer to the seller. You see, that means it's a question of fee simple. Partly, okay, I give you 10% discount and another 10 is free samples. Let us in other barter not allowed. Now see the instant case. In the instant case, the service said to have been rendered by the buyer for securing the service discount is an integral part of the transaction of sale itself, which incidentally confers on the assessee the benefit of popularization of the possessive goods in the market. The discounts were allowed is merely a percentage of the price of the goods sold, which has nothing to do with any other goods supplied or service rendered by the buyers to the assessee. The fact that a discount is not allowed at the time of sale, but on a later date at the end of the month, would not make it any less a trade discount. How do you apply this? So let me come back and dictate. What else? Don't trouble this court with so many judgments. One judgment is enough. I don't have the habit of writing long judgments. What? No, you are liable to pay tax, not by the notification. You are liable to pay tax by virtue of the schedule. On the first day. Now, what has happened in the notification? Notification clarified that look here, these 3 samples which you have been given, that can also be has to be a part of it as per this section. What is that? That they are looking to 110. Huh? Section 110. No, not 110, not 110, not 110. All of you have, both of you have made, tried to make confused. It's 10. Explanation 3. Explanation 3. Explanation 3. Let me come back. tried your best. And I gave you opportunity of heard Miss N. Alia, the learned counsel appearing on behalf of the petitioner, Mr. M.K. Bhuya. M. Bhuya appears on behalf of the respondents numbers 1 to 4. 1 to 4. What 1 to 4? 1 to 4, that's one. In all the three requisitions. Heard Ms. N. Alia, the learned counsel appearing on behalf of the petitioners in the three petitions, and Mr. M. Bhuya appearing on behalf of the respondent numbers 1 to 4 in all the three petitions. The issue involved in the three petitions are similar, taking into account that by way of the three petition, a common order passed dated 10/5/2018 passed by the Joint Commissioner of Taxes under the Assam Value Added Tax Act 2003 have been put to challenge for the different assessment years. Which one? Okay. You can pay. The notification is of 2006. How? Reassessment order for the period 2009-10 Let us see the order of reassessment. What book are you reading from? So from 30/10/2009,
There is no text.
there is no text.
It's only for 7, 8, 13.
This is another book.
See,
This is of 2010. This is of 2007. And this is of 2005. So 21 was omitted. So what happens corresponding to, if this is so, so drugs and medicine were no tax. Huh? Then there was no tax. First schedule. But schedule is free. That's it. The second sheet, no, first schedule is free. 5%. Started in 30/10/2009. So then it will be at which point, second schedule? Second schedule, which point? That I understand. What is the point? This section 10. No, it is at every point. It will be, no, you have to pay 5%. So only one difference is 1%. So then every point it will be a huge tax. No?
Also, there is one line in our affidavit in page number 3, if I'm not mistaken, where the medicine was subsequent to the relevant year in which this proceeding was going on. The medicine was entered in Schedule 4 of the Assam Value Added Tax 2003, taxable on MRP and governed by Section 10, where it has been clearly laid in explanation 3. But that we have written in our affidavit.
It's okay, but for the period from 2000, we are concerned with 3 periods. The 3 periods are 7-8 will come in, 8-9 will come in, 9-10 it will be 5% from 30-10. So there has to be some adjustment to be carried. Huh? So that 1% has to be adjusted. The petitioner herein in all the 3 writ petitions, the petitioner is the petitioner. The brief facts of the instant case are here as herein under. Instant cases are as herein under. The petitioner in all the 3 writ petitions are one and the same. The petitioner is the company incorporated under the provisions of the Companies Act 1956 and is a registered dealer under the Assam Value Added Tax Act 2003, for short the Act of 2003, as well as the Central Sales Tax Act 1956, for short the Act of 1956. The petitioner is also a registered dealer under the Goods and Service Tax Act 2017. The petitioner deals in sale of medicine in the state of Assam. It is the case of a petitioner that while selling medicines in the state of Assam, the petitioner also distributed free samples as samples to the retailer as a policy of medicines.
তুমি আহিলে মই নাম্বাৰটো দি দিছো ফোন কৰিলে কাগজ দুখন দিব লৈ আহি থাকবা
As per the provisions of the law on the sale of medicines and for promotion of medicines. It is the case of the petitioner that for all the 3 assessment years, that is 2007-8, 2008-9, and 2009-10, the Superintendent of Taxes, Unit A, Gauhati, accepted that the free samples which the petitioner distributed amongst the retailers were exempted from payment of tax and accordingly passed assessment orders. The grievance of the petitioner herein is that the respondent number 4, that is the Superintendent of Taxes, Unit D, Gauhati, initiated a proceeding for reassessment under Section 40 of the Act of 2003 for all the 3 assessment years. And thereupon passed reassessment orders, thereby levying levying tax on the fee samples and also the interest accrued thereon. It is pertinent to mention that for the assessment year, for the following assessment years, it is pertinent to mention that in respect to the 3 assessment years, the following amounts were found payable by the petitioner upon passing reassessment orders. 2007-8, that's correct. Madam, you ask a junior to provide how much? How much? Page paragraph 6 rupees so and so tax and here is interest. And I get tinta boso. The petitioner being agreed by the reassessment orders so passed by the respondent number 4 for the 3 assessment years, thereby imposing a huge tax liability as well as the interest thereupon. Preferred 3 revision applications before the Commissioner of Taxes and the same was endorsed to the Joint Commission of Taxes for disposal. The Joint Commission of Taxes by the common order dated 10/5/2018 dismissed the 3 revision applications, thereby upholding the orders of reassessment for the 3 assessment years. And it is under such circumstances the present petition has been filed. Record reveals that this court, by an order dated 9/11/2018, issued notice same date, na, madam? All the 3 notice. However, no interim orders were passed. Ms. Anna Havelia, the learned counsel appearing on behalf of the petitioner, submitted that as there was no interim orders passed, the petitioner have already paid the entire tax as well as the interest payable thereon. It is also very pertinent to take note of that as the order dated 10/5/2018 passed by the Joint Commission of Taxes, passed by the respondent number 3, is based upon a notification issued by the government of Assam, dated 11/10/2006. The said notification has also been put to challenge in the 3 petitions. The respondents have filed an affidavit in opposition wherein It was mentioned that the assessments so carried out initially of the petitioners were self-assessments. Isn't it?
Yes, Lordship.
All the three?
Yes, Lordship.
It is also mentioned that the petitioner had provided large quantities of medicine free of cost to the retailers in the form of quantity discount as a common practice of business, whose value runs into crores of rupees in a financial year. It was stated that these free samples were actually not free samples. It was also mentioned that the petitioner was afforded adequate opportunity before completing the proceedings in the matter of turnover escaping the assessment. But the petitioner did not even bother to produce the books of account nor to speak about adducing his case. It was also mentioned that going through the returns submitted of the audited accounts of the petitioner, it transpired that the petitioner paid taxes by multiplying the aggregate of the MRP as declared in his returns. He had not deducted the tax fraction from the MRP, which implied that the petitioner threw open to the market his product with a clear instruction that ultimately the customers had to bear the extra tax in addition to the MRP printed on the body of the package. And those goods which were given free as quantity discount or whatever name it may be, ultimately be sold to the public along with other goods. It was also mentioned that in view of such practices being followed of providing free samples, the government of Assam, in pursuance to the provisions as laid down in section 110 of the Act of 2003, issued a notification dated 11/10/2006, directing that the free samples along with the sale at the point of first sale in the state on MRP also be deemed as sale and shall be liable to pay tax on the MRP of such goods given free. Accordingly, proceedings under Section 40 of the Act of 2003 was conducted strictly conforming to the governing sections and the relevant notifications issued under the Act of 2003. The proceedings were concluded long back on 29/4/2015, and the demand notice thereof was issued and received on the same date. It was mentioned that the petitioner never bothered to pay slight importance to it and set on it. Resultantly, recovery proceedings were drawn, but the petitioner exhibited total disregard to those proceedings also, and he woke up after the recovery proceedings took effective turn. It was also mentioned that Section 10 provides the method of levy of tax on medicine to be taxed at the first point on MRP. And the petitioner never contested that point. The petitioner paid tax strictly following that method. The levy of tax later on changed, and the tax is levied at all points of sale where, even if goods are given free to retailer, tax is to be deposited by the retailer if he sold it to the customer. It was also mentioned that the petitioner followed the earlier system without contesting its validity and reaped all the benefits of that system and pumped goods into the market amounting to crores of rupees with the label on it, local taxes extra. It was also mentioned that the petitioners knew that though the goods at the first stage were supplied free of cost to the retailer as promotional measure, the goods would be sold by the subsequent seller. And since the goods were inscripted with local taxes extra as evident from his accounts, thereby burdening the customers to pay tax, and thus the petitioner cannot avoid the responsibility of the tax burden by accepting a part of the scheme and avoiding the other, after invoking the path of professing the dictum, local taxes extra. The respondents, through their affidavit, supported the order passed, impugned order dated 10/5/2008. 18, na? 10/5/2018. As well as, huh?
Yes, sir.
As well as the notification which was impugned in the instant proceedings. Earlier it was 4%. Now it has become 5%. Earlier it was 6%. But why in this affidavit it is shown 4%? This is for all this period, 2009 onward. This is 8/9. How do you know? So then it was increased. So you'll have to pay more then if we take that point. In the backdrop of this above, this court finds it now relevant to take, in the backdrop of the above pleadings, this court finds it pertinent now to take note of the submissions made by the learned counsels appearing on behalf of the parties. Ms. Anna Haveli, the learned counsel, first refer to the judgment of the Supreme Court in the case of State of Rajasthan and another versus Rajasthan Chemists Association reported in 2006 773 and submitted. That the imposition of the tax on the MRP was not permissible. And therefore submitted. That the impugned notification dated 11/5/2006 11/10/2006 cannot be sustained in law. The learned counsel further submitted, referring to Section 11 of the Act of 2003 and submitted that for the purpose of the Act of 2003, the taxable turnover in relation to a dealer liable to pay tax on sale of goods means that part of the dealer's gross turnover during the prescribed period which remains after deducting the various after the permissible deductions as mentioned in Section 11 of the Act of 2003, which includes the turnover of such other sales or such other amounts as may be prescribed. The learned counsel, referring to Rule 9 of the Assam Value-Added Tax Rules 2005, for short, the Rules of 2005, submitted that the determination of the taxable turnover as per the provisions of Section 11 various amounts specified in clauses A to H are required to be deducted, and it includes amounts allowed to the purchasers in respect of goods returned by them you are on B. Amount allowed as discount, provided such discount is allowed in accordance with the regular practice of the dealer or is in accordance with the terms of any contract or agreement entered into in particular case having a bearing on the price consideration, provided that the accounts show that the purchaser has paid only the sum originally charged less discount. She therefore submitted that the free sample so provided by the petitioner was a form of a discount. And as such, the price of the free samples has to be excluded while determining the taxable turnover. In that regard, the learned counsel referred to the judgment of the Supreme Court in the case of Deputy Commissioner of Sales Tax, (law), Board of Revenue Taxes, Ernakulam versus MS Motor Industries Co. Ernakulam, reported in 1983, 2 SCC 10A, and submitted that similar to Rule 9B of the Rules of 2005, Rule 9A of the of the Kerala General Sales Tax Rules 1963 was involved. The learned counsel, referring to the state judgment, submitted that the Supreme Court in categorically observed that a service discount is an integral part of the transaction of sale itself, which incidentally confers on the assessee the benefit of popularization of the assessee's goods in the market. The discount so allowed is merely a percentage of the price of the goods sold, which had nothing to do with any other goods supplied or other service rendered by the buyers to the assessee. The learned counsel appearing on behalf of the petitioner therefore submitted that the free samples that in lieu of trade discount the petitioner have provided free samples. And as such, the same should be construed as a part of a trade discount, thereby entitling the said amount to be calculated while determining that the said amount to be deducted while determining the taxable turnover. And take a seat. Per contra, Mr. M. Huya, appearing on behalf of the state respondent, submitted that drugs and medicine were brought within the fold of the fourth schedule to of the Act of 2013, 3. Explanation 3 to Section 10 makes it clear that when a goods are brought within the fold of Schedule 4, tax at the first point of sale has to be paid on the MRP. The learned counsel submitted that neither Section 10, neither Explanation 10.3 to Section 10 of the Act of 2003, nor entry 21 of the fourth schedule have been put to challenge. The learned counsel therefore submitted that under such circumstances, the petitioner cannot be allowed to question the mandate of Section 10, the Explanation 3 to Section 10 of the Act of 2003, as well as entry 21 to the fourth schedule. The learned counsel further submitted that the notification which was issued on 11/10/2006, which is impugned in the instant proceedings, is more like a clarificatory notification which have been issued to obviate the difficulties arising out on account of the common practice followed in the medicine trade to offer free units on sale, which results not only in the loss to the state exchequer, but also permitting the retailers to collect tax on sale of on such fee units. He therefore submits that without a challenge to Section 10, Explanation 3 to Section 10, as well as Entry 21 of the fourth schedule, the notification dated 11/10/2006 being a part of the said provisions cannot be put to challenge. He therefore submitted that the judgment in the case of Rajasthan Chemist Association cannot be made applicable to the present provisions, apart from the fact that the facts involved in the said judgment are completely different from the facts involved in the present proceedings. The Learned Counsel further submitted that no doubt Section 11 of the Act of 2003 stipulates the permissible deductions while determining the taxable turnover, as well as and further at clause D of section 10(11), it further stipulates that the further deductions, permissible deductions, would be available in the rules of 2005. The Learned Counsel therefore further submitted that Rule 9 provides the various permissible deductions. Referring to Rule 9b, the Learned Counsel submits that for getting the benefit under Rule 9b, it has to be, there are certain prerequisites to be satisfied, which includes Mr. Bhuya, I'm making your submissions good, so that tomorrow your state government can think that you can become one of the best here.
Much obliged.
But by the way, did you read the judgment?
Yes, Lordship, yes.
But the prerequisites to be satisfied, which includes that the amount allowed is as a discount and not as a free sample. Secondly, such amounts allowed as discount is in accordance with the regular practice of the dealer, or in accordance with the terms of any contract or agreement entered into in a particular case, having a bearing on the price consideration, provided the accounts show that the purchaser has paid only the sum originally charged less discount. The Learned Counsel further submitted that when it is a case of free samples, there is no, the said samples are not accounted for. Are they accounted? Let's see your annual return. Where did you show? See, annual return are unaccounted, and accordingly, it is, and accordingly, Rule 9B cannot be said to be satisfied in the present case. Analysis and determination. I've heard the learned counsels appearing on behalf of the parties and have perused the materials on record. In the order dated 17/2/2026, this court have already observed that the judgment in the case of Rajasthan Chemist Association cannot be made applicable to the present case. Taking into account that the issue involved therein is whether the taxable turnover of the wholesale distributor is to be calculated on the basis of the maximum retail price or on the basis of the price at which the wholesaler has sold the medicines to the retailers. The issue as to whether free samples can be deducted, can be permitted to, are permissible deductions in terms with Section 11 for determination of the taxable turnover is not an issue involved in the case, in the judgment of the Supreme Court in the case of Rajasthan Chemist Association. Further to that, it is also very pertinent to take note of that in the judgment of the Supreme Court in the case of Rajasthan Chemist Association, there was a sections which was challenged. Section Rajasthan Chemist, some section was challenged. Section 4A of the Rajasthan was put to challenge. Whereas in the instant case, neither explanations 3 to section 10 nor entry 21 of list of procedure to the of the Act of 2003 have been put to challenge. In the backdrop of the above, let this court now take note of the submission made by the learned counsel appearing on behalf of the petitioner to the effect that free sample being a form of a trade discount, the petitioner should be given benefit in terms with Rule 9B, read with the petitioner is entitled to the benefit in terms with Rule 9B, while determination of the taxable turnover in terms with Section 11 of the Act of 2003. This court finds it very pertinent to take note of that Rule 9B of the rules of 2005 are almost parameterial to Rule 4A, 9A of the Kerala General Sales Tax Rules 1963. The said Rule 9A of the Kerala General Sales Tax Rules 1963 came up for interpretation before the Supreme Court in the case of MS Motor Industries Co. Ernakulam Supra. perusal of paragraph number 5 of the said judgment would show that the Supreme Court observed that all amounts allowed as discount, where such discount is allowed in accordance with the regular practice of the dealer or in accordance with the terms of the contract or agreement entered into in a particular case, have to be deducted from the total turnover in determining the taxable turnover, provided the accounts of the assessees show that the purchaser has paid only the sum originally charged less the discount. It is further seen that in the said case, discounts were permitted, trade discounts were allowed. And such discounts were also shown in the books of accounts. Paragraph 5 and 6 of the said judgment being relevant is reproduced herein under. The question therefore arises from the above quoted provision, above quoted paragraphs of the said judgment. The question therefore arises as to whether free samples can be brought within the ambit of Rule 9B of the rules of 2005. This court now finds it very pertinent to take note of the rationale behind the notification dated 11/10/2006. Which is impugned in the instant proceedings. From the state, the contents of the notification itself show that there is a common practice in the medicine trade to offer free units on sale. But these free units which are being provided to the retailers are sold to the consumers against the price consideration. It is a fact which is seen from the materials on record that these free samples so provided also not only mentions the price MRP, but also mentions local taxes extra, thereby permitting the retailers to collect tax from the consumers. And it is under such circumstances by the said notification which was issued on 11/10/2006. It was mentioned, it was clarified that the free samples along with the sale at the point of first sale in the state on MRP basis shall also be deemed to be sale of such goods, and the dealer making such free samples at the point of first sale in the state shall calculate and pay tax on the MRP of such goods given free. Taking into account the said notification, it cannot therefore be presumed in any manner that Rule 9B, which postulates discount, would include free samples. Next. This code also finds it very pertinent to take note of that the assessment years for the various assessment years, which is the subject matter of consideration in the three writ petitions, are for 2007, 8, 8, 9, 9, 10. And the petitioner, being in the business, in the trade of medicine, ought to have known about the notification dated 11/10/2006, which was holding the field, at least till 31/10/2009, because it can't happen subsequent. Under such circumstances, the petitioner ought to have collected at least the tax on the free samples. Next. In the backdrop of the above, if this code duly takes note of the submissions so made, in this code duly takes note of the impugned order dated 10/5/2018, it is the opinion of this court that in exercise of the powers of judicial review, the respondent number 3 have not committed any patent illegality or any illegality or in any perversity for issuance of a writ in the nature of certiorari for quashing the impugned order. According, this court does not find any merit in the instant case for which the three writ petition stands dismissed, interim orders be finished, no cost. Yes, madam. Thank you for your book. Good night, sir. Now, what about that electricity?
Gauhati warehousing.
Oh, wait, your matter will. Here to this electricity, it's a very interesting dispute. What has come out from time to time?
I am appearing in 9, my other friend is appearing in 10. I am appearing in 9.
Now, you see, when the overload is shown, there cannot be an excuse that you have not inspected. You should have inspected.
My friend has some instructions regarding that.
What is that? And thereby impose 12 months. Madam, you get hold of your counterpart. Who is there? Mr. Kyle. Don't allow him to get away. No, not satisfied. The word used shall be limited. The word when it is used that shall be limited, it is the legislative intent that you cannot exceed 12 months when you cannot ascertain. If you can ascertain, you can. But then the question is, you have to ascertain that every month it has happened. When you had the opportunity out here to know that there was an overload, why on that day, because of your inefficiency at that point of time, of not carrying out the inspection, why should the petitioner be burdened for 12 months? Not satisfied.
Your Honor, in fact, if my lord, can you see this page, my lord, that we passed on, madam, along with the instruction prior to the inspection?
Yes.
No, prior to the inspection in question, the instant case, it was carried out on 24th May 2018. There was a regular inspection which was carried out on
17.
Yes, ma'am, 2017. And this inspection, my lord, we have to be fair, my lord. This inspection found the remarks as regards this inspection is there is nothing wrong with the meter and it is recorded as being accurate. So if we take this as the point of reference and go back to the inspection in question.
What is the date of inspection?
The date of inspection in as far as these proceedings are concerned is 24th May 2018.
2018.
9 months thereafter.
Then?
On that occasion, the second inspection, in the inspection in question where we carried that out, only then we found that there was unauthorized usage and excess load beyond the sanction.
So then also you can.
Yes, it will not be well. That is the point I wanted to.
So therefore, this is first is not 12 months, it is okay. But what about when you had the opportunity? You had the opportunity because you see, you have, my lord, a PDCL also has to appoint their officers, inspector, to look into it. I've given all the powers in one judgment that it is not required to be only the assessing officer, anybody can inspect because 135 does not say anything. Challenge?
No.
Really, so therefore the question now arises is, you have the inspectors who can do so. It is now provided in your bill. In the bill, it is being provided at that point of time. Nowadays, though, it is not no problem. It is not a problem. Earlier, the bill, it was provided. The moment there is an excess overload, You have to immediately take it over and make an inspection. This is being done, immediately take over because it is twice. But if you have made these 3, 4, 5 bills, and these 8 months, 7 months, so obviously you cannot do it prior to, this is 22, 8, 2008. So after this, are there any bills where you have not seen overload? Because all are these same meters.
After this date, there were 4 instances, my
So
lord.
4 instances, you can very well claim that two times. 4 instances you can, but the 4 instances which are not there, or for that matter that, because you have, the word using is during the period of unauthorized use of electricity. This is it's a word, it has a meaning that when there is an unauthorized use of electricity, it is nothing to favor him, nor to favor you. It is not a penal provision. It is a provision by which it has to be given a, what is that interpretation? Purpose. So if it is a purposive interpretation, you are to take it. Yes, we are to help or see. The basic idea is stop theft. Stop unauthorized electricity. Use of electricity shall be the basic idea. So therefore, when it is an unauthorized use of electricity by them, then you can very well charge for that period. Because you have a problem with your regulation. Till the regulation did not have the N factor or part of the month. Why the part of the month is being used? Problem arises there. When you see the part of the month, the word used is a dangerous thing. This is only
Fraction
for
of a fraction of a month.
fraction of a month. Means it can be for 1 month or half a month also, 15 days also. So you cannot mechanically apply 2 times. Where is my long order? Oh, this is Mr. Bhumik's scheme. General Manager, Rose Ken. So here, and number of months duly taking account of a fraction of a month. Fraction. So because of this is the problem.
My lord, the date of inspection, last date of inspection was 22/8/2027, 2017. So from that date up to the up to 31/4/2018, we can take this period as an assessment period. And one more observation, apart from whatever is written in my submission, apart from that, there was one more observation which I would like to explain here. So the thing is that our main detection was the excess load over and above the sanction load. So, my lord, the sanction load was 634 and 635, and the detected load over and above the sanction load was 422 kilowatt, my lord. Now, if I rely upon the maximum demand which is recorded in the meter, so when can I suspect that there is a overload over and above the sanction load? When it will surpass 635 kilowatt load recorded in the meter.
But it has to run for 30 minutes.
Yes. When there will be an when there will be a load over and above the 635 kilowatt load.
Mr. DGM, let me tell you one thing. The meter is for giving you a signal. Then look here, there is an overloading. The duty is reposed upon you by the act to carry out an inspection.
My lord, but
and the moment you find while carrying out an inspection that look here, this is the overload because these are the other machineries which are being connected. Not only you are going to cut off these connections, but also you impose It is not that nowadays it is not required, but at that point of time, one thing was very clear. You are given a signal. Then look here, there is an overload.
My lord, I understand. Just the thing is that contract demand will be as per the requirement of the consumer. So, my lord, I just want to say that if suppose a consumer has 100 kVA sanction load, he can avail even 20 kVA also as a contract demand. So, in that case, if in a particular month the recorded demand exceeds that 20 kVA, then we will levy an overdrawn penalty in the bill. But that no way indicates that he has a load more than sanction load, because his sanction is 100 kVA. That's what I want to point out.
When he has a contract demand, first is the sanction load. Sanction load is 100. Let us take an example. His contract demand is 50. That he says that although I have got a sanction of 100, but I'll only use 50. If it exceeds 50, wouldn't it show in the meter overdrawn?
Yes, if it exceeds, it will be reflected in the meter.
That's all.
That's recorded. But his sanction load is, my lord, 100.
That's a different thing.
So,
but doesn't it violate the contract demand?
Yes, sir, my lord, contract demand and connected load, these are different terminologies, as I have explained in the last. My lord, what I want to say is, if someone has availed 100% of the connected load as a contract demand, in his case, the overdrawal will significantly indicate that yes, there is an overdrawal. But if someone has availed 50% or 60% of the total connected load as a contract demand, so in that case, if it exceeds the contract demand, then you can.
What is the connected load and sanction load? Same. Sanction and connected same.
My lord, in most of the cases it is same.
Because it becomes same. Because the last time I asked you, you said at the end of the day both are same.
Yes, my lord. But I am talking about the contract demand and connected.
Understood. So therefore, the connected load as well as not the contract, the contract demand and the connected
Connected load. In their case, my lord, their sanction load was 635 kilowatt. That amounts to 747 kVA. And in their entire record, I have checked, the maximum demand in case of overdrawal, which was recorded, the highest maximum demand recorded was 597 kVA.
But he had a contract demand of 422.
They had a contract demand of 485 kVA.
480. But it went by 522.
I'm talking about 2017.
Whatever may be.
Yes.
So therefore there is an excess.
They had a contract demand of, my lord, 485 kVA.
Hmm.
So, and
Connected load is 485.
connected load is, my lord, 635 kilowatt. That means
No. Here you see there is again a problem. See this document. Sanction load is 635. See that document you gave it to me. Connected load is 485.
My lord, connected load, sanction load, same.
Then how is it different? 635 is sanction.
The 485, that is contract demand, my lord.
So, but it is used as connected load.
That may be a meter. You can check the bill, my lord. And in the agreement also, it is written as 635, my lord.
Where is Mr. Pallov Bhomik? I think we need to close it. Enough is enough.
Apologies, Lordship. He had to leave for his doctor's appointment.
Huh?
He had to leave for his doctor's appointment, Lordship.
Doctor's appointment.
Yes, Lordship.
Mr. DGM, I've understood it. So the thing is, I will interfere with that order only to the extent to direct you to reassess, taking into account that the period within which it has been found that the petitioner has unauthorized on the basis of the which is reflected in the meter. Wherever you impose that twice the amount and take them. As regards the earlier period, you see, the thing is like this. While the petitioner is liable to make payment for unauthorized electricity, you are also imposed with the responsibility under the Electricity Act to look into it, make an inspection when there is a transgression. So if you have, you take over and find if you have documents to the effect that yes, now it has come down to 8 months. 8 months?
Yes,
As per them, it has come down from 22/3/2007, 22/8/2017 to 8/5/2018. So it has now come down drastically for that 3-year period. So that is one period. But then also, if you have anything else, because here it is okay, so you cannot have it till the earlier period, because when you have done it, you cannot say the next day he has committed unauthorized electricity. So it has to be on a date where you find it from your meter. Any overload which is there, where you are paying overall penalty, that will be set off. Certain amounts have been paid, they will be set off. But you will be charging him as per this calculation and then minus. But anyway, I have understood it. Your presence is not required. I know you are a busy person. So we have it on 25th to close it, because Mr. Bhumik is not there, because I am going to dismiss his petition. So when you dismiss somebody's petition, he may say that my doctor's appointment was there. So we'll have it on that and dismiss his petition.
If I may, Lordship, on the 25th, he will be out of station, Lordship.
Oh, then doesn't happen. It cannot happen. He can go to his doctor. You want time for doctor tomorrow.
So tomorrow's the
Okay, Friday. Friday, I have four matters. Item number 1, 2, 3, top of the list. Then the next top of the list, second in the top of the list. We just close it. List the matter on Mr. So-and-so, the learned DGM, Mr. DGM Commercial and Revenue APDCL is present before this court. And he further explained before this court and present before this court. A draft, a written note have also been placed before this court during the course of the hearing, which is kept on record and marked with the letter X. In addition to that, inspection report of the petitioner's premises held on 22/8/2017 was also placed, which is kept on record and marked with the letter Y. Taking into account that the related repetition, taking into account that the counsel for the petitioner in WPC number 6512/2017 is not present. List this matter on Friday, next day, at the top of the list. For final dispute. Kuntu. No, itu no. Itu kuntu. No, itu lombuli kuntu. Wait, yeah, so itu no. Wait, take it. Just wait. I will. Yes, madam. Get one satisfaction of allowing your petition.
Lordship, this is my senior Mr. Executive with the court premises because of medical emergency of his mother. Lordship, my senior has given an instruction.
See, you got hold of your colleague in this manner.
Lordship, they have given an instruction that, Your Lordship, a similar matter is pending in the Supreme Court, Lordship, and my senior is instructed to submit this order. Lordship, so they are agreeing that it is covered by the Bombay High Court judgment. The matter has gone to Supreme Court. That is true. And Lordship, because the Bombay High Court has held the judgment in our favor, the circular has been interpreted. The Supreme Court, Lordship, they have filed the department has filed, there is no stay.
There is no stay, but don't you think that we should await?
Lordship, I leave you.
You have having an interim order?
Lordship, there is no interim order.
Yes, interim order is there now. Not interim order. Some interim order is passed by somebody.
Yes, your lordship.
No interim order.
23-6.
What is the case about?
Lordship, this is whether, lordship, there is an exemption that if I am doing a warehousing of agriculture produce, that is exempted from payment of GST. That is on record, lordship, by way of notification. Now, lordship, they have issued a circular stating that no, tea is not an agriculture produce, and tea on warehousing of tea, lordship, you will have to pay tax. The Bombay High Court has held that no, that circular cannot override the express provision of law and a notification which is issued thereunder. The tea is an agriculture produce. This is what has been held following the judgment of this lordship Supreme Court judgments or earlier judgments stating that tea is an agriculture produce. So since tea is an agriculture produce, the warehousing of the tea will be exempted from payment of lordship GST. This is what has been held by the lordship Bombay High Court, division bench of the Bombay High
Your
Court.
senior is also an income tax counsel?
Lordship.
Is he? When can we see your senior? Let's have it on Friday or Thursday. Let's have it on Thursday. Because you see, tell your senior that when it is an agriculture, you see, tea, income earned from tea, isn't it part of exempted under the
Rule.
the agricultural income tax act?
Yes, your lordship. Yes, your lordship. Rule, there is a bifurcation.
As for the agricultural income tax act, is it on, what is the levy? Levy is on what?
Lordship, under
Is it on the production of the tea or on the?
Lordship, under Rule 8 of the Income Tax Act,
There is a bifurcation.
there is a bifurcation. 60% goes to the agriculture.
Is it on
40%
the
business.
construction? Agricultural income is exempted.
60% totally exempted.
60-40 is, no, this 60-40 comes only in the agricultural income tax act.
Yes, sir.
But section 10 of the income tax act exempts the agricultural income.
Yes.
Income. But agricultural income is there, but there is a diversion taking into account the certain aspects by which it cannot be. Therefore, by a deeming fiction, Rule 8 comes in, and therefore 60-40.
60-40.
That is what I understand. So if that be so, if a income tax on Assam agricultural income tax, is it on Métis? Just find out whether it is a Métis. Métis, would it be an agriculture year? Because there are many judgments also on the case of wealth tax also. I think there is one judgment from our High Court also which went to the Supreme Court. Pertaining to a land, there was a, what you call, the case of wealth tax. It's a case of wealth tax. They were having an arrow strip inside the tea garden.
Okay.
So there, a transfer which was sought to be made as to whether this continues to be an agricultural land for the purpose. Because agricultural land again is outside the purview of the surface.
This is the division bench judgment of Bombay High Court, which has gone to Supreme Court, lordship, which has interfered. Lordship. Lordship, I'm really sorry. No. Lordship, does it contain the head note? I've given the answer copy here. It contains the head note, yes.
Okay, we'll have it on that day. We finish it off.
Whatever.
So it says that it still continues to retain the flavor of an agricultural.
And therefore, the circular which has been issued beyond the lordship cannot be sustained. In this case, lordship, there was an additional thing they filed an lordship
So they should
advance
have
ruling also.
notified the notification. No. It is provided under what? Exemption?
Lordship, the exemption is provided under the lordship, the notification under the GST itself.
And circular is there are many judgments of the Supreme Court also, no? That circulars are interdepartmental.
And
They
they cannot
cannot lay
override
down the law.
notification. And they cannot override notification when it is
No,
exempted
no,
under the.
therefore the circular is only applicable to her, US central government, not to her. It's a matter on Thursday. Yes, Mr. H. Brother. Oh, this one.
This matter, but we are basically the order of the plot of land. We are agreed by the fact that a notification, an order has been passed within the Geographical Survey of India. They say that this land of the petitioner, they fall within the prohibited area and within the prohibited zone of an ancient monument called Devi Dole in Orissa, my lord.
Yesterday I passed
Yes,
one on.
my lords have dealt with the issue yesterday in item number 12, my lord. 12. But we have a different case slightly because my land has already been identified way back in 1990, wherein this court has said categorically in an order judgment that my land falls outside this prohibited area and it is not within that prohibited zone. And the
How did the court say?
yes, my lord, that what happened, my lord, in 1990, my lord, in 1990, I filed a writ petition basically challenging an order wherein, my lord, my settlement.
But how did the court say in 1990, taking into account that section 28, 20B and 26
came much
on
later.
16/6/1992?
Because at that point of time, when this settlement of the current petitioner, the predecessor in interest of the current petitioner, his father, land when he was holding, my lord, he wanted a settlement of his land. So the government gave him settlement, but thereafter the settlement was cancelled. Cancelled at the behest of some complaint given by the people in the neighborhood saying that you cannot give settlement to these people because it will efface and it will ruin the ancient monument that is Devi Dole, and so settlement cannot be granted. Malak, on this particular point, when court examined, court called for all the records pertaining to the land where it is located the land of the petitioner. So from the cadastral map, what I could learn from the judgment and the material, the court have seen the records and have found that this under which the land of the petitioner was situated was much away from the monument which they claim to be within 100 meters, was much far away.
No, Mr. Burama, there are two aspects. One is section 10 say, 20A says that it is a prohibited zone within 100 meters.
Correct.
Then you have 20B, which says it is a regulated zone within 300 meters from the 100 meters.
So what my current case is before law is that one aspect of the matter that my land is outside the zone which my lord will examine. Second aspect is also there, my lord. When I was going through this act, my lord, the 1958 Act and the rules clearly indicate that before the authorities claim that a particular plot of land falls under prohibited area or prohibited zone, my lord, there is a procedure prescribed under Rule 31, 32, and 33, wherein the authority will have to notify by an official gazette publication saying that the land of Mr. X falls within this particular prohibited zone. So you are notified, you need to file your response or objections. And if you don't file
that is for acquisition.
No, that is exactly there in the rules of 1955, my lord. That rules of 1959, Archaeological Survey Rules 1959, Rule 31, 32, and 33, stipulates that particular procedure. My case is, my lord, done a very simple premises that without even giving me that notice that my land falls within the prohibited zone, when you have basically demarcated the land and have given a notification saying that 100 meters under 20A and 20B is the land of.
Let's see the impugned order.
Yes, my lord.
Why there are two impositions?
But two persons have filed actually the contiguous land, so two impositions have been filed.
Have they filed reply?
Everything has been filed by the Archaeological Survey. They have filed a response, my lord. We have filed a reply to that.
What do they say?
My lord,
They normally give photographs.
yes, my lord. They have given a photograph in my case also.
Eh.
And what they say, basically, my lord, is that my land is at 200, but 2 meters. As a external boundary. The Act says, the rule says that it has to be 100 meters from the protected monument.
No.
No, not from the boundary, not from the boundary. my lord.
No. Let us see.
My lord, my lord, the interim order, if I'm not standing, takes up.
Let us see 28. Yeah, 28. Let's see.
Page, my lord, 67 is the interim order, my lord.
Where is 28? Every area beginning at the limit of the protected area or the protected monument.
Yes, my lord, monument.
Limit of the protected area.
My lord, 1 minute, my lord.
Then it may, in some cases, it may be inside also, if you are submitting that.
Protected,
Come to section 20A.
20 of the act, my lord.
Ah,
28.
ah.
Declaration of prohibited area and carrying out public work or other work in prohibited area. Every area beginning at the limit of the protected area or the protected monument. Here in my case, my lord, it is a case of protected
As the
monument.
case may be.
Protected monument.
No, why you are going to protected monument? What is the protected area has also been defined somewhere.
My impugned order says that you are within the vicinity of protected monument, not within the protected area, my lord.
Where is the protected area? Prohibited area.
Prohibited area.
Means an area defined or declared to be prohibited under 28. Then, as the case may be, an extending to a distance of 100 meters in all directions shall be prohibited area in respect of protected area or protected monument, provided the central government may increase the size. Save as underscored in Human Section 20C, no person other than an authorizer shall carry out the in case where the central government or the director is satisfied, it may be necessary so and so. Then any amendment to section A, no permission referred to in subsection 3, including carrying out any public work or shall not be permitted. And these have been done. Then where the rules? Harmony has completed in unauthorized construction within the prohibited demand. Where it is here? Within the prohibited area.
Before that,
You are issued notice on 2011. You are in the same state. By carrying out the aforesaid construction, the operator has contravened the provisions of subsection 1 of 20 and thereby liable for action under so and so is secreted, prohibited of the section to remove any such unauthorized mark. Where is it mentioned? What is the distance? Beginning at the limit of here. Now, where is the report of the circle officer? Unauthorized construction first floor completed. Where is it mentioned? Within what? We should get a report from the circle officer.
may kindly report it just one moment.
No. The court would not help you. This court is not a court for giving declaration.
No, I'm not on that.
Where?
Only on one point, my lord, before my ban is declared to be under 28, my lord, they need to follow procedure under 31, 32, and 33.
Let us see.
Kindly, I may take the lord to my rule 31, my lord.
Yes, mining operation and construction area, notice of intention to declare.
Declare a prohibited area or regulated area. Before declaring an area near or examining a protected monument to be a prohibited area or a regulated area for purpose of mining operation or construction of both, central government shall by notification of official gazette give 1 month notice of this intention to do so. And notification shall be received in a conspicuous place near the area. Second is very
So did you raise that issue here?
Yes, madam.
And what is their reply?
They have till now have not been able to produce the notification under which I was made known that my land is under the prohibited area. Because in some of the hearings done on earlier occasion also, they were always directed to produce the notification. They have failed to produce it. Every such notification shall specify the limits of the area which is to be so declared, and shall also call for objections, my lord, if any, from the interested persons, my lord. 32 says, my lord, declaration or prohibited area or regulated area. After expiry of 1 month from the date of such notification under Rule 31, and after considering the objections, my lord, if any received within the said period, central government may declare by notification official gazette the area specified in notification under Rule 31, or any part of such area to be a prohibited area, or as the case may be, a regulated area for the purpose of mining operation of both. Effect of declaration of prohibited area, my lord, no person shall other than a authorized service. So this is how it follows, my lord.
Now they invoke 38 for removing this unauthorized construction I have made, my lord. First, they will have to show that my land is within this prohibited area and that they have given a notification to the effect.
Wait. My thing is, when was this amended?
This was amended in 2010, my lord. But
Where?
it was given, the amendment act is, my lord, here.
No, where the rules have been amended?
The rules continues, my lord. Some of the rules pertaining to 28 regarding, my lord, the definition, they have made some amendments.
No. My question is, see, 2010, they brought it with in effect till 1992, retrospective effect. So my question is, who is there in their video?
I am, my lord. I'm for the a guide for central government, my lord.
Huh? A guy is there.
Yes, my lord.
Let me wear my specs. I may not be able to see.
My lord.
So
Yes.
the question is, so therefore the question is, whether these rules were amended, my question is. Then how do you get the expression of prohibited age? How do I pardon me? Whether the rules were amended, taking into account that it is only in 2010
My,
the concept of 28, 20B, 20C were brought in,
yes, ma'am.
giving it effect from 1992.
Yes, ma'am.
The question is whether the rules were amended, Nan.
My lord, amendment, my lord, here what happened in 1992, that was declared the prohibited and restricted area, my lord. That notification is on, that is book is, my junior will hand over.
Where?
My lord, nine.
Huh? Ancient monument calculated with
My lord, kindly come to page number 50, my lord. Notification is there, my lord. 50, yes, ma'am.
Okay. Central government gave 1 month's notice of its intention to declare areas up to 100 from the protected limits and further 200 meters near or adjoining Iman to be prohibited and regulated area for the purpose of both mining and construction dated so-and-so, whereby notification in the government of so-and-so, published in Iman gave area. Designation of the officer categories of Iman. Where is your pillar?
My, that is in now, that is in the last part, my lord. Down, therefore, exercises the power conferred in the section 30, rule 32.
Huh?
Last paragraph of page number 50.
Rule 32 of area hereby declare the said to be prohibited area. There shall be, this shall be in addition to and not to any previous to the similar declaration already made in the monuments. So and so, 1,000 pillars, road, so and so. Where is Gori?
Dola is, my lord, in my affidavit in opposition, page number 84, my lord.
Where is Gorisagar?
Yes. My lord, in page number 84 of my affidavit in opposition, my lord. I'll kindly come to page 84 of my affidavit in opposition, my lord.
84. Yes.
Here, my lord, the 3rd August 1937, my lord, it was declared the Bidol as an prohibited monument under monument area.
From notification. Numbers were to published in the Assam Gazette in which following answer in the district of Chile were declared to be protected within the meaning of the said act. Okay. Devidol. Did Bishudol, Shivadol, Devidol.
Yes, my lord.
No. We are no, Mr. Counsel. You see, kindly see section 39, repeal and saving.
Yes, my lord, that is there. Yes.
Historical so-and-so mentioned shall cease to be in effect in relation to the incident and so-and-so declared by the act to be unlawful except in respect to things done or omitted to have been done before the commencement of this act. So, we finish it off when? Day after.
Yes, my lord.
Day after. We finish it up, dismiss it. How many dismissal I'll give you, Mr. H. Bravo? Okay. Matter heard that part, list the matter again on Friday, Thursday, for final disposal. It was ready. So therefore, your case is, we keep it this one, we will again study.
Yes.
Pick it up on ready. And this, because this notification, why is she referring to this notification?
Difficulty is this 1992 notification does not per se identify my land. What my case is, my lord, when you pick a gazette notification identifying my land to be falling within the prohibited area, which the act contemplates, you come up with a vague and a blanket notification identifying only.
Are you challenging this notification?
No, I did not. Because why? I did not think I'm submitting my lord.
Okay, then we will heal. I have a meeting now.
Yes, sir. I'm obliged.
Ask them, please.